Assalamu alaikum and a very good morning. We are pleased to welcome you to the second day of the conference under the title The Interplay of Islamic Ethics and Human Rights. Please be reminded that translation is available, so all you have to do is pick up your channel number 2. We also want this conference to be interactive, so please use the hashtag CILE 2023 on Twitter to share your thoughts. We will now proceed to the first session of the day, moderated by Dr. Alexander Cairo, the Associate Professor of Islamic Studies at the College of Islamic Studies in Hamad bin Khalifa University. Dr. Alexander, the floor is yours.
Okay, assalamu alaikum everyone. Thank you very much for the opportunity to moderate this exciting panel. We have two speakers, and since we're starting a little later, we will also end a little later. Our first speaker is Dr. Marwa Ozaikal, who is an assistant professor at Istanbul University in the Faculty of Theology. She has a BA from Ankara University Faculty of Theology and an MA from the same place in Islamic law. Her PhD was from Sakarya University Faculty of Theology with a PhD thesis entitled Utilization of the Human Body and Organ Transplantation According to Islamic Law. Dr. Marwa will speak to us today on a related topic. The title of her presentation is making money from the body a right? Islamic jurisprudence, ethics and human rights, and the problem of commercialization of the body. Dr. Marwa, the floor is yours.
Can you see the presentation? I don't think so. Can you help with this? Sorry. I think it is not shown. I think I can start. Assalamu alaikum. First of all, thank you for CILE Center for organizing this great symposium conference. And I would like to talk today about as you can see, is making money from the body a right. And you know, the title is like very wide, so you can think about the prostitution, surrogate motherhood, organ sales. A lot of issues can be included in this under this title, but I will inshallah focus on the issue of organ sales most because I recognize that it's a very wide title. So inshallah I will concentrate on the organ sales part. So should I start or should we wait? I don't know.
Do we have IT support at hand?
Okay, so should I wait? Okay. Okay. It's okay. Okay. I don't know.
All right, so apologies for the delay. Dr. Marwa will start her presentation without a PowerPoint, and hopefully the problem will be solved as she goes along. So the floor is yours. Thank you.
Okay, thank you again. I'm sorry for this interruption. Okay, so I'm really sorry that we cannot have PowerPoint, but I will follow from here. Okay, so making money from the body, actually I will concentrate on the organ sales issue, organ trade. Actually, first of all, I will start with the approach of the fuqaha to the body in general, and then I will focus on the selling and buying body and body parts from the classical period to today, and I will give the opinions of classical fuqaha on this issue, and then I will continue with the modern ulama's opinion on it and some fatwa committee's opinion, and then I will try to find a conclusion. Okay, so when we look at the understanding of body in fiqh, we exactly see they say that the human body has karame, first of all, it has hurme, and it has isma. When we read the classical books, actually, with this eye, I can say, we can find a lot of information regarding this. Actually, it was surprising for me to see these kind of discussions, whether we can utilize from our body, can we sell, can we benefit our organs or body parts, blood, teeth, milk. There are lots of discussions regarding this. The first question is, can we benefit from them? And the other one is, can we sell them? Can we sell them? These questions are like we can find in classical books. So they say that human body has its karame. So like human, they exactly say this word, like human being, the body and body parts has its karame. They are respectful like human being. They say this. Because of this, they say that even you cannot benefit from any body parts, especially Hanafi ulama say this, you cannot benefit from them because it has karame. This is not because they are najis, they are not impure, but they are respectful like human body, like human as well. So we can see that they say hurme, you cannot touch the body of anyone, even he or she is dead or alive. Even you cannot take a hair from a person, you cannot touch the body. These are actually general information regarding the body. So they give emphasis to the saying that the real Malik is Allah. On the body, they say this, and it's a kind of emane for us. So there are rights of Allah on the body. So actually we can discuss what is the right of Allah on the body, because it is not something concrete, you know, it's something abstract. So what is exactly rights of Allah on human body? You know, some ulama discussed about it, and for example, Muhammad Naim Yassin from Jordan University, he claims that rights of Allah on our body is to keep our health in a good manner, so that we can obey and practice our ibadat. That is what he claims. And okay, when we look at the opinion of classical ulama regarding the organ sales, body parts, you know, in the past it was not possible to sell organs inside, you know, but you can sell hair, blood. After that, you can sell some organs, of course. They discuss these all issues. And when we look at their definition of goods, mal, property, actually they say that, especially Hanafi ulama uses the words of mutakawim mal. So they say that human body is not something mutakawim. The body parts are like this, so you cannot sell and buy body parts because they are not mal al-mutakawim. You know, according to Islamic law, you cannot something cannot be subject to the contract, like wine, alcoholic beverages, and pig, these kind of things, they are not mutakawim. So similarly, organ and body parts cannot be mutakawim. And for example, Sarakhsi says the good, the mal is things outside of us that were created for us to benefit. And Nesefi says things other than human beings created for the benefit of man. And then they emphasize that they are other than us, other than human being. So human being cannot be subject to the selling or buying issues. And the common point among ulama is they say that you should benefit from a mal, muntafa'un bih, and it should be permitted by Sharia. So if these two conditions are existing in something, then we can consider them as mal. So we can think in this way. So in the past, people wouldn't benefit from organs or body parts in that manner like are today, right? So we can ask, is it true to compare these opinions to our today? Actually, maybe being muntafa'un bih is something different here, because also Hanefi Mezheb says that only things that can be used under normal conditions, like without necessity, can be illegal goods, mutakawim mal. For example, you can use wine or pig if there is a necessity, but under normal conditions, you cannot sell and buy them, so they are not mutakawim. Similarly, we can compare this opinion to the organs for today. Yes, we can benefit from them, but not under normal conditions. Also, actually, as I mentioned earlier, there are lots of discussions regarding the selling body parts. And when you look at the Hanefi's book, in the title of Al-Bay'ul Fasid, we can find that they are exactly, openly, clearly, they said that this kind of selling or buying contracts are invalid. They are batil. Actually, they are batil from one perspective. They are invalid because they are not malil mutakawim. But from the other perspective, it is haram because it humiliates the human and human body. It is contradicts with the human dignity. They clearly say this word, what is interesting for me. And when you look at Sarakhsi, Ibn al-Humam, Ibn Nujaym, Marghinani, Ibn Abidin, in all Hanafi books, they discuss these kind of issues, and they say they think that no part separated from the body can be subject of a contract. They justify this with the principles of respect of human body and their organs. They clearly state this. The parts of human body are also like the body, and therefore the contracts on it are invalid, they say. They cannot be sold because they are respectable, not because they are najis. لَيْسَ بِنَجَاسَتِهِ بَلْ بِكَرَامَتِهِ, they say. Because of this we cannot sell. And they say this kind of things humiliate the human body, devaluate the body. Okay, when we look at the discussions, they talk about blood, hair, teeth, bone, and milk. They discuss whether we can buy and sell these kind of things. And especially they talk about milk a lot. But before this, maybe you can think that selling or buying these kind of things in the past was different. So how can you benefit from hair, for example? And we know as a second reason, maybe, Prophet Muhammad says, لَعَنَ اللَّهُ الْوَاصِلَ وَالْمُسْتَوْصِلَ. So you cannot benefit from a real hair of a human body. So maybe because of these prophetic saying, they said so, you cannot benefit from it, and also you cannot sell. But when we think it is for beautify, right? So can we compare taking organs from someone if you are in a necessity situation? So I'm not sure whether it is true to compare something, but I will just give some examples. And they say that because of the respect for human body, we cannot benefit from a real hair. And in this hadith, Prophet Muhammad talks about the real human hair, not some other types of nylon or some other kinds of hairs. So you can use them, but you cannot use for a real use a real hair. So maybe the most striking discussions are regarding the human milk, mother milk. They discuss whether we can benefit from human milk and sell and buy for them, because as traditionally even Prophet Muhammad ﷺ has a milk mother, so they discussed in the Jahiliyyah Arab time and after Islam, we continue to pay for milk mothers. So the question arises, what is this money about? So if we can pay for mother because her milk, so does it the money of the milk directly, or is it a kind of renting the mother, or it is the money for labor, or she gives time, she has to feed herself in a good manner, something like this? Actually, there's a strange argument here by Shafi and Malikis. They claim that actually milk is the only thing in human body that we can sell and buy. There is an exception here. It is different from other body parts. First of all, it is clear, it's clean, and the other thing, it is a food for baby. So if you sell clean things and clear things and like food, so it has created with this aim, so you can sell directly, you can put in the cap and you can sell the women milk, they said. But in Hanafi books, they directly reject this opinion, saying that this is not the money of the milk, this is only for labor and for mother, actually, because she gives times and some other things. It's a kind of renting. In classical fiqh books, you rent the mother for a time and then you give the money. So Hanafi ulama does not accept this opinion, so they say that you cannot benefit from mother milk if there is no necessity. This is created for baby, the baby needs it. So the other opinion might be, in Hanafi Mazhab, they say that it's a necessity for baby. So if there is a real necessity, only in this situation you can buy a milk from another woman. But if it is a real necessity, so when we take the discussion to our today, so can we compare organs to the mother milk? Because if there is a necessity, especially in the past, the only option was the mother milk for baby. Like today, we didn't have other alternatives, right? So they discuss saying that it is something like very crucial for baby. So it is a necessity. If there is a necessity, we can buy or sell mother milk, they say. Okay, when it comes to today, we see the most ulama, they think that it is haram to make trade from organs or selling, buying, especially Said Ramadan al-Buti, Yaqubi, Sandehli, Shankiti, Hassan Ali al-Shazili, Ahmed Sharifuddin. You can see in their works, they directly say that it is haram and it is batil at the same time. It is an invalid act if you do this. And when we look at some fatwa committees, like Mejma al-Fiqh al-Islami al-Dawli, Presidents of Religious Affairs of Turkey, Darul Ifta al-Misriya, they all reject this opinion. But only Islamic Fiqh Academy India and Islamic Fiqh Academy for Rabitat al-Alam al-Islamiyya, they say that if there is a real necessity for the recipient, if he or she couldn't find anything other than this organ with money, then he can pay to save his or her life. But from the other perspective, you can ask the question, so can we make same thing if I in a necessity situation, can I sell my organs? They don't make any explanation regarding this, but also it should be important. If it is permissible to buy, then you can sell maybe. Actually, I don't know whether it's a good comparison, but we should answer this question as well. They say like classical fuqaha, it is gayr mutakawwim, so it is not your own property, so you cannot sell it. It is a humiliation of the body. It contradicts with human dignity, and it is not suitable for maqasid sharia. And one of the maqasid sharia is protecting life, and related to this, protecting body is also one of the maqasid sharia. And they say that set the dhari'a principle is important here as well, because you have to block. Okay, maybe organ transplantation is permissible for them, but if you don't block this permissible thing, some of them reject organ transplant as well. So if you open the door, then it will be organ trade, they say. And we have some opinions like they give jawaz, permissibility. For example, Muhammad Naim Yasin from Jordan, and Wehbe Zuhaili is a famous faqih for today, and they say that organs can be sold to meet a necessity or obtain a greater benefit. People cannot find organs. If we let people to sell and buy their organs, the problem of organ transplantation and waiting list can be solved. It's a greater benefit, they say. And they say that if it is permissible to use organs, it should be permissible to sell them. But as we mentioned earlier, even in classical period, they differentiate between using and selling. And they said you can use if there is a necessity, but you cannot sell it. And they said we can imagine like the money of organ is like the money of medicine, because it's a kind of medicine. If you can pay for medicine, you can pay for organ, they say. And they make a comparison between diya or arsh, which is a compensation in Islamic law. So they claim that if someone harms to your body, give harms to your body, then he should compensate it. And they give money for this. So it's like blood money, you know. So they compare to this, saying that then maybe organs have values. For example, for a teeth, 5 camels, you know. So can we compare with this? So can we say that organs has their values? And they refer to the opinion of Shafi Mezheb, saying that like selling a mother milk is possible, so that we can sell because of the necessity. And also they compare to the sale of Mus'haf, the Quran. They say that in the beginning of Islam, it was not permissible to sell and buy Mus'haf because it has a sanctity. It is the word of Allah. How can you sell and buy the word of Allah? So it was a discussion in the first, but then they saw that it is not the money of a word of Allah. It is the money of the book, papers, and inks, etc. So, and they say that like in the beginning of Islam, actually, people would say, when we look at the first classical books, they say that selling, taking money for imamah to praying, and for these kind of things, for calling azan, to teach fiqh was impermissible actually. But then they said that they became necessity to take money, otherwise we wouldn't find anyone to make this imamah, reciting azan and something like this. So they say that maybe 20 years later we will accept all of them because we will see their benefits and we will accept as community, they say. And yeah, okay, actually I was planning to talk about the example of Iran, but I don't know how many minutes I have. So I will just shortly talk about it. Today, as an Islamic Republic of Iran, they have a system. You can sell and buy your kidneys actually. So they have charity association for support of kidney patients. So in Tehran, this system brings together the kidney donor and receiver, and they even make trade actually between these parties. So this system is appreciated of by a minority of writers from the Western and Islamic countries on the grounds that it resets organ waiting list. But most majority of people, academics, they criticize this system. And when we look at this system, people would think that Muslims are selling and buying their organs. This might be a common opinion, but it is not true. Actually, before they have this system, they took the opinion of Shia ulama, Ayatullahs, so they gave the permission for this. And maybe I will not go into the detail, but they use the word, it is permissible to sell everything that is permissible to donate. If you can donate it, you can sell it, because they claim that there is a classical understanding. But Sunni ulama say that it is permissible to donate everything that is permissible to sell. Actually, the principle is like this, but they make it in a different way, and they say you can sell the organs. But they forget that the organ transplantation or donating your organ which were created on your body is only permissible because of the necessity. But you forget the necessity things and then you sell that. If it is permissible to donate, then you can sell organs. This is a problematic approach for me. So actually, alternatively, in Islamic world in West, they talk about giving a gift after transplants. And in West, it is called reward and gifting. Can it be alternative for organ trades? So they claim that there might be some monetary rewards, such as life and health insurance. The recipient can do this, awarding a medal of honor or money, covering travel expenses, the hospital expenses, or as state can be tax deductions might be possible. These are discussed. When it comes to the Islamic world, there are different opinions. Most ulama accept gift after donation, compensation, reward, they generally accept this. For example, when we look Muhammad Ali al-Bar, he's a faqih and a physician at the same time. He claims that financial donations, which is not donation, can be made to the donor to encourage the organ donor and to compensate the organ donor's absence from work for a while. Because he gives his organs, he cannot work for a while, so we can compensate their needs for this period. And Yaqubi says that actually we can give money to the donor or their family because they lose something like their personal expenses. And also he claims that we can pay money for organ banks or blood banks so that they can use this for preservation of organs or these kind of things. And Yusuf al-Qaradawi, similarly, it sees permissible to give a prize under the name of a grant, for example, and he claims that it is mustahab, it is even nice to give such a thing, because Prophet Muhammad says that when you take that, give in the best way. So he claims that the person made some goodness for you, kind for you, so you have to give something instead, he claims. And Jadul Haq, Ali Jadul Haq, and he says if it is necessary to save the life of the patient or the injured person, a price can be given as a gift in return of the cost of medicine, but it is not permissible to discuss it before organ donation, he says. Okay, maybe as a concluding conclusion, actually, like in the classical fiqh opinion, it shouldn't be permissible for a person to give up his bodily integrity and obtain a material price because the human body and body parts are not mutakawim according to Islamic understanding. And the other thing is, it shouldn't be because of this, actually it shouldn't be subject for the contract. Actually, it looks like it is contrary to human dignity and honor. Actually, the other problem here is the donor and receiver, they know each other. Actually, in the systems in the world, even donor and receiver don't know each other because they might be another problems, like he can treat all the time during the life, he can want money, extra money, this kind of problem. So they even don't know each other. So, but in Iranian system, for example, they know each other. This is another problem. So if the system is not well organized, even you say gift or award is this kind of this, and there may be a danger of opening a door to the organ markets. This might be a problem. And the motives that lead people to donate their organs should be sake of Allah. So you should self-sacrifice, and there should be a sense of solidarity and mutual love, mutual respect. And if the money comes, all these feelings might be go, and it might be a problematic approach from your perspective, actually. And we can say that, yeah, maybe because of the losses, such the donors covering the expenses, like hospital expenses, funeral expenses, might be discussed, but I'm not sure about them as well. We have to think about it. And yeah, maybe as soon as payment, prize, or gift to the donor is accepted, the reasonable amount of money or price should we talk about. So how much can I pay? Can I give a car, give a house, for example? What is the limit for this? So what is called as prize or gift will be another topic of discussion. And I would like to finish here. Thank you for listening.
Thank you so much, Dr. Marwa, for the wonderful presentation, and apologies once again for our inability to show your slides, but it was very clear, and so hopefully it will stimulate a lot of interesting discussions. I will ask you to hold your questions until the second presentation. Dr. Ayman Shabana, who might be familiar to many of you. He's our colleague here based in Georgetown University in Qatar. He's associate research professor there. He has a PhD from the University of California, Los Angeles, an MA from Leiden in the Netherlands, and a BA from Al-Azhar. He's one of the leading figures in Islamic bioethics today and has received many grants to work on the Islamic Bioethics Project. Today he will speak to us on, he will present to us a paper entitled Islamic Discussions on Human Dignity and the Right Not to be Born. Well, the floor is yours, Dr. Ayman.
Right. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullah. And good morning to all of you. Thank you very much, Dr. Alexander Cairo, for the kind introduction. And also I'd like to thank Dr. Samir Rashwani and Dr. Ghali, Dr. Al-Khatib for the opportunity to come and share some thoughts about this important topic in this very important conference. I feel honored to be part of this event. So the title of my presentation today is Islamic Discussions on Human Dignity and the Right Not to be Born. And the outline, I can see it, you can't So hopefully sometime it will show up. Basically, I'm going to address four main points. Start with the right to life as a basic right or a fundamental right, and then impact of modern medical technology. And under that, I would like to discuss and elaborate more on how much different applications of medical technology are used for different purposes, including preventive, curative, or therapeutic, but also increasingly enhancing purposes, from the right to life to the right to quality of life. And I think this is a very important transition and a very important transformation that is slowly kind of taking place, either we realize it or not, both at the beginning of human life, as we will see in more detail in the presentation, but also at the end of human life. And when we talk about human life here, we talk about mainly bodily kind of health, as it is measured in the physical state of the body for the most part, from a purely medical perspective. Right to life and reproductive medicine. So I'm like to, for the purpose of this presentation, I would like to concentrate on this domain of reproductive medicine within the larger medical structure. Under that, there is reproductive rights and related qualifications. So when people talk about a reproductive right or a procreative right, what does that mean? Does it mean right to procreate, period, or right to procreate a child with specific characteristics or features, right? This has to do with reproductive goals and also expectations, increasing expectations about the outcome of this reproductive process. And then I'm going to, time permitting, concentrate on two examples of prenatal tests and also pre-implantation tests. And I would like also, the fourth point, to touch on the concept of dignity and some subtle or nuanced discussion about the concept of Islamic dignity in general, but more particularly from an Islamic perspective. So, since this is a conference about human rights, it goes without saying that perhaps one of the most basic or fundamental rights is the right to life, right? It is upheld in both religious and secular normative systems, right? Almost all religions indicate and emphasize the importance of the right to life, but also secular system, legal or ethical, right? Most constitutions, different types of laws, legislations, etc., oftentimes emphasize the importance of life and its protection, etc. The Universal Declaration of Human Rights in Article 3 indicates, quote unquote, everyone has the right to life, liberty, and security of person. Usually, this right is anchored within a broader understanding of the inherent human dignity. And of course, this is and continues to be subject of so much debate and discussion from a philosophical perspective, from a religious perspective, from a legal perspective, etc. But be that as it may, oftentimes this right to life is translated into a number of ethical or legal principles, including, for example, sanctity of human life or body, respect for the human person, and also it is enshrined in a wide range of ethical and legal codes. When we talk about the right to life from an Islamic perspective, we can clearly see in the Islamic foundational sources and scriptures this emphasis on life. Most importantly, the famous ayah verse in Surah Al-Isra, chapter 17, verse 70, we have indeed honored the children of Adam. وَلَقَدْ كَرَّمْنَا بَنِي آدَمَ. Also, speaking about Islamic law and Sharia, we know in Maqasid, preservation of human life is a fundamental value under Sharia. It is one of the main 5 values along with religion, intellect, progeny, and wealth. Also, speaking about Sharia and Islamic law, we know that protection of human life is one of the main objectives of Islamic penal code in particular. There are this severe punishment that is stated for the crime of murder or homicide, and even in the case of unintended or unintentional killing also there are consequences. So in chapter Ma'idah, another important verse, وَمَنْ أَحْيَاهَا فَكَأَنَّ النَّاسَ جَمِيعًا, and whoever preserves it, that is the life of a human, one single human, it would be as if he has preserved the life of all humans. Now, we shift a little bit to the focus of the presentation to discuss what that actually means when we keep in mind recent developments that were facilitated mainly by biomedical technology and the various applications of that technology, and this kind of shift from right to life to right to quality of life. So genetic technologies, for example, have transformed medical practice in deep and significant ways. For example, they have improved predictive techniques to foresee and preempt anticipated medical problems. They have changed the traditional goals of medicine from healing to prevention and even enhancement. One of the main areas of medical practice that have been radically impacted by this genetic revolution is reproductive medicine. Genetic applications at various stages of the reproductive process have increased the degree of control over the result of this process, also increased expectations about the outcome of that process. Changing perceptions of illness and also disability and even death. So pregnancy with a malformed fetus or birth of a disabled child are increasingly being seen as preventable mistakes. Not only that, but when that happens, that's pregnancy with a malformed fetus or birth of a child with disability, for example, is increasingly seen as a potential area for compensation or torts against physicians or somebody who is involved in this process. Also, rise of new types of moral and legal claims depending on the jurisdiction and the different legal systems. So we see, for example, phrases such as the right not to be born, and on the basis of that, some people can bring up, some sort of can take legal action or bring up suits against physicians or some other types of medical professionals. The concept of wrongful life is increasingly also being discussed in philosophical debates and discussions to indicate this notion that that a lawsuit can be pursued or brought up either by parents or later on by the children affected, right? So wrongful birth or wrongful life. There are various kinds of claims depending on the jurisdiction we are looking at. So for example, I have a slide here showing the situation in the United States where these terms are used: wrongful birth claim and wrongful life claim, and also wrongful pregnancy conception claim. You have to look at the various jurisdictions, various states, because laws vary from one state to another when it comes to whether there is existing legislation, for example, about these issues, or whether it has been discussed in case law, for example. So in general, we have this new emerging area that is sometimes referred to as reprogenetics. That is the combination of genetics or genetic technology, especially genetic testing, and reproduction or reproductive medicine. And here I refer to this area as having some sort of a double-edged nature or sword, if you will. Of course, they have brought up a great deal of ease and facility in people's lives. They have increased their choices, enabled them to make decisions that were not possible, say, a few decades ago. But at the same time, they have also raised unprecedented moral questions and anxieties. So there is moral responsibility when it comes to these reproductive choices and decisions. There is a need for serious ethical reflection about all these types of queries. So genetic testing in the area of reproduction, there are several types of tests, including carrier testing, predictive testing, diagnostic testing, prenatal testing, neonatal or newborn screening for detection and early treatment of certain diseases, especially congenital disease or disorders. And then there is also pre-implantation genetic diagnosis or screening that goes or starts at a very, very early stage, even before pregnancy commences, in order to screen the most viable, ovum or sperms, etc. So there are ethical reservations associated with genetic testing in general. So each of them has its own particular nature and therefore associated reservations. But in general, there is a gap between mere discovery of genetic risk and appropriate responses to such risk. So what tests often do is they reveal or they discover, a particular disorder. But whether there is there is a treatment for that or not, this is questionable. Sometimes yes, sometimes no, and this oftentimes results in mere anxiety and worry on the part, especially of the couples, the husband and the wife. Knowledge of one's risk for genetic diseases can only cause emotional and psychological harm or distress. Results of genetic testing are usually rendered in probabilistic language, estimating percentage or likelihood of risk with a particular population. So oftentimes results are not certain, but they are rather probabilistic, phrased as probabilistic, and that of course complicates the decision-making process almost for everyone, but most importantly for the people affected, in this case, of course, the couple or the pregnant women in particular. There are also other issues associated with direct-to-consumer instruments, so oftentimes people now are taking hold of these kinds of instruments on their own, and also management of incidental findings. When it comes to Islamic ethical evaluation of genetic applications, when we examine Islamic or Muslim responses to these kinds of questions, we can clearly distinguish two main levels of analysis, as I tried to indicate in some of the earlier work that I have done on this. What we can refer to as ethical legal on the one hand, and then theological moral on the other. So at the ethical legal level, mostly what I mean by that is juristic articulations in the form of fatwas or opinions, fatwas either collective or individual, or resolutions by important juristic bodies, etc. And oftentimes when we examine this kind of legal or juristic discourse, we see that the overall concern of the jurist here is very close to or similar to the concern that a lawyer has, right? That is procurement of benefit and avoidance of harm, of course, to the extent possible. The other important level, which is kind of deeper level of analysis here, is the theological perspective or view which has to take into consideration a wide range of theological principles, starting, for example, with divine creation, human nature, and fitra, the scope of human freedom in relationship to divine decree, among others. So this two-way analysis may help explain and guide the process of genetic counseling within the Muslim context, and this is an argument that I have made before. So to look a little bit more closely at the question of prenatal genetic screening, it includes several types of tests that aim to detect any type of anomaly that may affect the life or health of an embryo. The most important ethical question that prenatal genetic screening raises is, as you can imagine, the question of abortion and the extent to which abortion is permissible, particularly in the case of genetically affected or malformed fetuses. Classical debates on abortion and the centrality of ensoulment are, of course, very important in this connection. So any kind of opinion on this modern query has to be anchored within this larger pre-modern debate or discussion on abortion in the Islamic legal corpus, which is, of course, quite extensive and multifaceted. Multiple prophetic reports describing embryonic life along two main stages, prior to ensoulment and post-ensoulment. The former stage is further divided into three main periods, each lasting for 40 days. The mainstream opinion, both in the pre-modern period and also in the modern period, among scholars of Islam, estimates the ensoulment to happen after 120 days. Of course, there are new kind of opinions also here, mainly in light of modern medical technology and also research, where some Muslim scholars have tried to look again at this question of ensoulment and whether the phrasing of the hadith means actually 3 consecutive periods or whether they are 3 concurrent periods, which means that ensoulment in this case happens within the first 40 days. Of course, our colleague Muhammad Ghali has written on this. For those of you who are interested, you can read his article on this question in Zygon. Aborting affected fetuses. The juristic debate on the permissibility of aborting affected or malformed fetuses are shaped by two main considerations. The first is the larger debate on abortion. In there are 3 critical points. First, characterization of ensoulment as a major turning point in the life of the fetus. Second, attitude towards permissibility of abortion prior to ensoulment. And then third, the impact on the life of the pregnant mother. And then the second consideration is nature and severity of the malformation as measured by scientific knowledge and technical expertise. So, for example, the former Mufti of Tunisia, Muhammad al-Habib ibn al-Khawja, who died in 2012, in this discussion he distinguished 4 main types of fetal malformations. The first 2 are what he refers to as simple and curable, and these are not grounds for abortion. While dangerous and incurable, they may justify abortion, but prior to the passage of the first 120 days. I list here on one of the slides an illustrative example of a resolution by Majma' al-Fiqh al-Islami of the Muslim World League, and I think it is quite illustrative of the current Muslim, mainly Sunni, opinion on this question, which pretty much summarizes what I just stated earlier. So, opinions concerning abortion of genetically affected or malformed fetuses make a clear distinction between pre-ensoulment and post-ensoulment periods, usually marked by the 120 days threshold. During the pre-ensoulment period, opinions are usually more lenient, but they vary depending on a chosen attitude from the related pre-modern juristic discourses, the Malikis, for example, versus the Hanafis. Some compare termination of affected fetuses and euthanasia. That brings us back to this question of beginning of human life and end of human life, and the question of quality of life. And when that comparison is made, I think it reflects the overall or the mainstream Muslim opinion on euthanasia, which it condemns, euthanasia. So in that sense, also termination of affected fetuses, especially in late stages of pregnancy, are often frowned upon. But it's very complicated, of course, and oftentimes it is investigated on a case-by-case basis. But in general, I think this kind of reprehensibility, if you will, or apprehension has to do with perspectives on the question of illness and disability in general. From an Islamic moral and spiritual perspective, these cases are supposed to serve as lessons in humility and also gratitude to the individual affected, but also to the community and even the world at large. Also, life of a disabled person could be extremely useful and may entail a great deal of benefit for humanity. Everyone, I think, can relate to that, can bring up examples to basically illustrate this point here. Effective solutions could become available in the future for currently untreatable diseases. And this is also another important point. Now, moving to the other example, which characterizes preconception measures in the case of pre-implantation genetic diagnosis, oftentimes referred to as PGD. It is usually placed within broader discussions pertaining to preventive or precautionary measures to avoid genetic conditions before conception. That include premarital genetic testing, immunization against certain disorders, raising awareness about risks associated with certain social or cultural practices, such as, for example, consanguineous marriage in some regions, temporary or permanent measures to prevent pregnancy, and also fetal sex selection, especially in the case of sex-related disorders. PGD aims to circumvent future genetic problems, particularly in case of familial history with genetic disorders. The most important stated benefits of this procedure include obviating the need to abort affected fetuses. Some researchers point out its high cost, difficulty of ensuring genetic safety in general, but only of specific disorders, and also limited availability. When we talk about Islamic evaluation of PGD, from a juristic perspective, oftentimes the main focus is on expected benefits against anticipated harms. So this kind of calculus or moral calculus that oftentimes jurists and also ethicists and lawyers sometimes engage in. So in general, there are religious reservations which pertain to IVF in general, and these include question of aura or uncovering, especially of female private parts. I mean, that will happen in the process. Possibility also of confusing the gametes of married couples with those of third parties in case something goes wrong, especially in labs, or how these samples are handled by lab professionals. Some jurists give priority to preventing these harms, and therefore they argue for impermissibility. Others, on the other hand, give priority to the anticipated benefits, which are deemed far greater, especially when the process is undertaken by trusted, reliable, and authorized specialists. And from this perspective, oftentimes people who espouse this kind of view, they invoke the concept of necessity, which we heard about earlier. So necessity overrides prohibition, and also a lesser harm takes priority over a bigger harm. أخف الضررين. Now, moving to the question of human dignity and how it has been affected by these developments. So in general, when we talk about dignity, we think about impact of illness and disability on the conception of human dignity, and how has that changed, you know, in the wake of these developments, right? So certain medical conditions seriously impact one's quality of life. So here, from this perspective, human dignity is affected, right? Is seen as affected, it has been decreased, if you will. So the experience of illness or disease somehow is perceived from especially purely secular or materialist perspective as somehow diminished, right? In some cases, they may result into a life that is not worth living, right? Negatively impact one's aspirations to live a meaningful and dignified life. And from this kind of perspective, also oftentimes we hear statements or phrases such as live or die with dignity. That is, I think what's meant here is without humiliation. And I think in this presentation, we can see this kind of contrast between something like humiliation and humility. For example, I think this would be an important kind of comparison to pick on in this respect. Problems associated with the moral decisions, or with moral decisions involving embryos and fetuses in particular. This includes the fact that decisions are often made on the basis, as we noted before, probabilistic data or test results, but also this purely kind of materialist or secular perspective tends to impact negatively on the rights of the disabled, people who already have, people who already have disabilities and disability rights. Also move and shift in the role of medicine from curative to preventive, preemptive, and also enhancing goals. But most importantly, I think that one of the most important implications here is that it brings to memory this kind of eugenic history, or the history of eugenic practices that were undertaken, especially in some places such as, you know, Germany under the Nazi regime, but also in the United States. Now, I come to a very important part of the presentation, that is Islamic conception of human dignity, mainly in light of some contemporary kind of reflections, especially those by the famous Moroccan thinker and philosopher Taha Abdurrahman. So Taha Abdurrahman presents this very interesting kind of discussion on human dignity, but he starts actually by placing it within the larger Islamic view of the world. And here he compares what he describes as a hard view and a soft view. النظرة الغليظة النظرة الدقيقة. This is my own translation. So the first one I take to represent the materialist, secular kind of view, and here it reflects one's material or bodily existence in this worldly life. The second one, the soft or subtle or deep view, it reflects one's immaterial or spiritual existence beyond this worldly life. And within this framework, he talks about levels or ranks of dignity. And these ranks include 3 degrees, if you will, hierarchical ones, if you will. He starts with what he calls al-karama al-taqdiriyya. And here I translate as initiative human dignity. And the reason I choose this translation, because what he means by this is innate, instinctive, and even primordial notion of dignity that started even before birth, before conception. It has to do with this covenant, you know, that from the Quranic or Islamic perspective, that was held, you know, in a different realm, you know, in a different kind of sphere, where God actually brought all people who will come to this world, you know, and basically made them testify that He is their Lord, with reference to the famous verse in Surah Al-A'raf. So initiative dignity. The second is evaluative dignity, and he refers to this as al-karama al-taklifiyya, and as the term indicates, what he means by that is one's role and capacity to discharge duties and obligations. And this involves also interaction with others. So it's not only about the individual, but how he discharges these obligations and these duties, in the community, in the society, in the world, right? And that involves also the question of testing and tribulation, etc. And then the third is al-karama al-tafdiliya. I translate as the superlative kind of dignity. And what he means by that is that it demonstrates one's capacity to reach higher levels of moral excellence. So here also, this type of karama involves one's relationship also with others and with the world at large. So I conclude with these remarks here. Assessing the implications of novel questions in the area of reprogenetics cannot be limited to legal calculation of benefits against harms. Beyond ethical legal analysis, a more comprehensive examination of these implications in light of core theological concepts must be undertaken. Such examination should include, though should not be limited to, religious meaning of illness, pain, and suffering, role of devotional means such as prayer and efficacy of causes, meaning of religious decree and submission to God's will, scope of human intervention, and finally, meaning of human nature and inherent human dignity. Thank you.
Well, thank you very much, Dr. Ayman, for this wonderful presentation. We have now time to discuss both papers. So if you have questions, please raise your hand. Yes, so we have two questions here from Dr. Muhammad first, and then you.
Assalamu alaikum. Thank you so much for the two very interesting presentations. I have one common question for both of you about the concept of human dignity. I spoke about this and I discussed this with the colleagues yesterday. The concept of human dignity is a problematic one when it comes to bioethics in particular. We have the famous publication from the President's Council on bioethics, of bioethics, entitled, I think, Bioethics and Human Dignity or something like this, where they discuss about these problems. When you read this work, it comes to your mind, the critique some people have against maqasid, higher objectives of Sharia. You can use them to get to any conclusion at the end, even to conflicting confusions. It looks like from their critique in the work, also human dignity can do the same in bioethics. So in end-of-life care, we can tolerate passive or even active euthanasia because we care about human dignity, or completely the opposite, objecting DNR and everything because we care about human dignity, etc. So I think, specifically considering the particular theme of the conference, we need to have something about human dignity. And at least how do I, as an author or presenter or as a bioethicist, a Muslim bioethicist, I see it. If we cannot find agreement on everything, at least the approach. So for instance, how would human dignity should be conceptualized or is actually conceptualized and then applied to the case, let's say, purchasing organs, or right to be born or not to be born, because it can be used both ways. We can say we tolerate selling or buying organs because we want to save human life and this is dignity, or we do not allow this because this will be cutting in the human body and this is against the human dignity, etc. So It's a big issue that needs. The other quick question for human purchase, you speak about selling, buying, gift, etc. There is also an idea, I've seen an article about it, but I don't remember having discussions in Islam about it, organ swapping. So you have two persons, they need organs, one give to the other, and then they swap the organs. How would you see that? Thank you so much.
Would you like to collect a few questions and then answer them in groups of 3, perhaps? Is that okay? I realize. Yes. All right, we have a question here. And there.
Thank you both so much. Those were fascinating presentations that raised so many questions, but I'll try to limit it. So my first question for Dr. Marwa, I was wondering if you could speak more to whether there's a balance in Islamic ethical approaches towards balancing the dignity of the human body of the donor and the dignity of the life and human body of the recipient, if it's a balancing question or if it's more of an inquiry into whether it's permissible to either donate or sell for the donor, full stop. That's the question. And I know you addressed this a bit through the doctrine of necessity, but I think that's a little bit different, because if it's a necessity, then it's sort of like an exception. But if it's a balance, then perhaps it's not so much that it's an exception, but that perhaps there's an argument that it's actually desirable, right, to preserve the life and dignity of the recipient. And so I'm curious if it's a balancing test or not. And perhaps a related question for Dr. Ayman is this idea of balancing. So you mentioned different perspectives on the permissiveness of abortion, and I'm wondering, is it ever considered obligatory? For instance, in a situation where there's a fetus that cannot possibly survive and there's a risk to the life of the mother, would there ever be an argument where that's a situation where it would be maybe not just permissible but actually desirable, right, to preserve the life of the mother if the fetus certainly can't survive? And one more, Dr. Ayman, I was wondering if in your discussion of the wrongful birth and wrongful life suits, if there's any distinction within Islamic ethical perspectives between allowing a financial recovery that doesn't claim that the birth was wrong or tries to undermine the dignity of the person who was born, but simply recognizes that there are increased medical costs. And so I wonder if there's a distinction at all, like there is in American law, between compensating someone for the harm of the birth versus simply reimbursing someone for medical costs that they didn't sort of consent to in advance, or whether those are considered the same thing. So thank you again.
Okay, so the final question for the first round is for the gentleman on the right. Yes, please.
Thank you very much for giving me the opportunity, and thanks for the 2 papers. One question for both. Now, we've been talking about human dignity a lot, and a lot of the time, especially from human rights perspective, when we talk about human dignity, we are thinking about respect of the other. It's always respect of the other. Now, we have cited وَلَقَدْ كَرَّمْنَا بَنِي Adam, and from that perspective, inherently, it is God that gives us that inherent beauty. Now, what of self-respect? Now, from the perspective, in the Western Kantian, perspective, he speaks about self-respect. And from an Islamic perspective, is it arguable to say that, well, actually, the respect of the other starts from self-respect? And also, for example, in relation to selling body parts and some of the points you make, what role does self-respect play in this in relation to ethics? Because a lot of the times it's about the respect of the other rather than, self-respect. So I thought I should just put this question on the table and see how.
Okay, so who would like to start? Marwa, yes.
Thank you so much for these contributions. Related to the concept of human dignity, I thought similar things with Doctor. For example, related to the euthanasia problem, in the West especially, they claim that you came at the end of your life and you have no consciousness, you don't have anything to do, so it is not suitable for your dignity. For example, this is the dignity claim as well. But from the other perspective, Muslim claim it is not suitable for your dignity. If you want to die, you need to protect your life. This is also a human dignity argument. So similarly, in organ transplantation issue, for example, they say who rejects organ transplant, they claim that it is not suitable for human dignity because Allah has created you in this body. Even your death, after your death, your bodily integrity should be protected, etc. And some other claims that it is respect for the others and for yourself, because people will remember you with your kindness if you donate your organs, and but maybe it looks like your bodily integrity is violated, but actually you are going to be more respectful if you donate your organs. So you're right, there are two different aspects of this term or concept, so we need to think about it more and more. So how can we understand human dignity? So actually I'm not sure whether the word of human dignity is a true word for Islamic tradition, because honor is something different maybe, but we generally talk about kerame, respectfulness of the human being and human body. We don't have such a concept actually, so we have to discuss about it as well. So relating to the swifting organs, actually I know ethicists has discussed it, but I don't know any Muslim scholar who discussed related to this issue, so they might be accepted by some. So relating to the balancing, actually it is the basic thing for Islamic law to balance maqasid, maslaha and mafsada. So in organ transplantation, so benefit and harm balance is very important, you know. So when it comes to necessity, it is another issue. So they say that the necessity make the impermissible permissible. And ulama, fuqaha put the necessity under certain circumstances, and they said that to have a necessity condition, you have to have in a difficult situation. Otherwise, if you don't take this organ, for example, or haram thing, you would die. So actually today we use this necessity word in a like really easy way, but in the past they say necessity is the only situation if you die, otherwise, or if you lose your organ, for example. So actually the concept should be discussed as well. I think darura or necessity, but in general, to balance between maslaha and mafsada is something difficult, you know. So you have to consider all situations so that you can compare them. Yeah. Okay. So maybe we can.
Thank you very much for the questions. Starting with the first one here, Dr. Muhammad Ghali. I agree that there is need actually to there is need for more clarity when it comes to the question of human dignity. But I think what I was trying to do here in the presentation, and hopefully in the paper, I'll try to do, at least try to do part of that, is to highlight this messiness or fuzziness or even ambiguity that surrounds the issue of dignity. But I think it starts with a broader conceptualization of what we mean by a human being, right? The human body, this is a kind of a reductive understanding of the human being, or is the human being or the human person is more than the human body? I think this is very important. So if it is the first, then yes, dying with dignity, living with dignity, all these kinds of, that would apply. But if you situate human dignity within a larger theological, philosophical, moral kind of setting, then that would bring, as Taha Rahman tried to to show that the issue is not limited either to the human body nor to the human life, right? These are just parts of the discussion, but it doesn't include everything. About a question about whether in the juristic discussion there is ever this notion of obligation to undertake abortion in the case, for example, of a situation to save the mother, the pregnant woman. There are discussions in the juristic discourse, either in the past, in the pre-modern period, but also in the modern period, about these kind of scenarios or cases. And it is definitely one of the most important grounds used to justify what is otherwise something that is considered haram or reprehensible, etc., right? Especially after the installment. So this is one of the main justifications to undertake abortions, to save the life of the pregnant woman. And this is done, to use the juristic kind of logic or language that they use, in order الحفاظ على الأصل, right? You sacrifice the branch in order to save the origin, or the trunk of the tree, if you will. So here, the life of the mother is seen as the source of life for the fetus. So if there is any kind of competition or conflict, then logic says, from this perspective, that you save the life of the source rather than the derivative, right? Having said that, there were also jurists, and I think Yusuf al-Qaradawi in his Fatawa refers to that, the late Muslim renowned scholar and jurist. He said that this doesn't apply in all situations, because oftentimes this decision is conjecture. So when you say, we need to do this in order to save the life of the mother, we can't say that with absolute certainty, right? If we say that, then fine. But the reality of the situation is not all cases kind of fit this kind of paradigm example. Because from this perspective, especially after installment, the fetus acquires this kind of human personhood and human status, and his life becomes almost equal to the life of the mother. And I think, if anything, this refers also to this emphasis on human life as a principle, right? That in the case of the fetus, you need to preserve, human life as well, not just people, ordinary people, or even born kind of babies or children. But the other point you raised, wrongful life and wrongful birth, and the grounds for compensation, for example, and whether this can be seen a way to defray, financial cost. I think that there is room here for discussion, because even in Western kind of legal discussions on these issues, both in Europe but also in the United States, people talked about what is at stake here is not really compensation for wrong life or wrong birth, but the inaccessibility to information in critical times, for example. So it boils down to that, not actually the question of wrongful life or wrongful birth. But I think there are variations there also. I'm not so much kind of familiar with this entire discussion, but I think this is what I can say about this, at least for now, if it makes sense. Yeah. And then the final question about self-respect. Thank you very much. I think this is a very important point. But that begs the question, where does it come from, right? Again, from an Islamic theological perspective, it comes from God. It's God, after all, who endowed humanity, or the human person, with this inherent dignity and therefore respect, both, from the perspective of the individual himself, self-respect, or in his interaction with others. And what comes to my mind as I say that is the divine kind of source of this notion of human dignity, I think, would guard against this notion of self-respect to devolve or to develop into something like egoism, for example. Right? You can talk about self-respect, and then when you emphasize it so much, it turns into some sort of fixation or concentration on the ego, right? But what would guard against that, at least from a spiritual or theological perspective, is that it comes from God. So you need to handle that with humility rather than arrogance, if that makes sense.
All right, thank you very much. So we have time for a second round of questions. There's a question here, then one here.
Thank you. Assalamu alaikum. Thank you so much for the papers. I really enjoyed them. For Dr. Marwa, I have a question. Can you briefly share with us the permissibility of organ donation? Because I wasn't aware, so I was following your paper up until the point with respect to buying and selling, and then it seemed like the schools of law. What would be just very briefly, if you could share the reasons for why it might be considered permissible. And for Dr. Ayman, I wanted to ask you just a quick clarifying question. For the three categories of dignity that you relayed toward the end of your paper, can you just repeat for us the term used by Taha and then the translation that you've rendered?
Yes.
And then just one question for whichever one of you would like to take it. What would be a legal and an ethical Islamic perspective on refusing medical care, which may be life-saving, presumably, but for different reasons, like perhaps for either painful treatment or maybe quality of life, or chemotherapy, or people who are end-of-life care in hospitals. In the U.S., a lot of times I don't think there's an option, or perhaps even socially it's not considered appropriate to refuse certain types of care in that situation. So what would be the legal and ethical perspective on the right to refuse medical care, which may or may not be curative or life-saving? Thank you so much.
Okay, thank you very much for very informative and interesting presentations. Well, I'm mainly concerned with the line of ethical, legal, theological reasoning behind the discussions of all these issues, new issues. So, well, first of all, I find it a little bit problematic, or we need to problematize the sort of depending on classical discussions on some of the issues. Well, of course, there's some inspirations, for example, by the discussions of the Hanafis about karama, hirma, and isma, so dignity, etc. But one of the issues, I mean, from the discussions that you presented, they don't have in their perception that this part of human body is very much useful. It can save lives. This is not in their horizon of thinking. So for them, of course, it's problematic because you are just kind of getting rid of some of your body or selling it or whatever. So it's clearly there's no use of such a thing. It's meaningless. So in this sense, I don't find it like it's a little bit problematic to depend on these discussions to consider it mal mutaqawwam or غير متقوم, worthless property or not, stuff like this. This is one issue. Another issue is that the formalistic analogies is really also very much problematic, like to make an analogy with the mushaf or diya and stuff like this. Well, this is too much formalistic, and we should also discuss this. I mean, to which extent can we base our decisions, I mean, bioethical decisions on these kind of analogies. The issue of, I mean, the recurrent argument that the human body is God is the owner of the human body, not we. Well, yeah, this is, I think this. So my point is that in some modern legal discussions about these issues, they raise cases. I mean, I find it problematic to raise cases like necessity. I mean, the whole issue of donation or even selling is a case of necessity. There's nobody is taking like out his healthy kidney for another healthy kidney, right? So it's always a case of necessity. But the issue, there's also, I also need to benefit from your, what do you think about the slippery slope argument, which is, well, donation is okay, but selling is problematic, not because it's different from donation, but to prevent exploiting the poor people, or to prevent creating a market where the less benefit class of society being misused or exploited. So I think I should stop here to leave the space.
So I have a follow-up question actually that builds on what Dr. Samar was saying, that for both of you, if I may, which has to do with the kind of reasoning that jurists develop when they tackle bioethical issues in both cases. So I think you've shown us very nicely how they rely on scriptural texts, how they draw on Islamic legal traditions and on juristic formulas. But your presentations also touched on a different kind of reasoning. Well, maybe we could call it prudential reasoning, right? That focuses much more on outcomes and consequences that are psychological, sociological, economic in nature. So I wonder whether you could comment on the centrality of this kind of reasoning. For example, in relation to organ transplantation, issues relating to not only the waiting times, but also the problems of organ trafficking and underlying conceptions of the marketplace as an equal or unequal sphere of exchange. In the cases of genetic testing, maybe the kinds of levels of anxiety that individuals might feel, but also more broadly, what kind of society is being created through the extensive use of these biotechnologies, not only for the preservation of life, as you pointed out, but also increasingly for the enhancement. So how central do you think this kind of prudential reasoning is in the way these jurists reason, and whether the centrality or relative centrality of this form of reasoning might also help us understand why jurists differ in the kinds of conclusions that they reach?
Lots of questions. Yeah, okay, I can start. Yeah, thank you. Related to the question of organ transplantation for Dr. Zara, thank you for your question. So actually, of course, before we talk about the commercialization of the body part, maybe we have to be clear about organ transplant. But we know today there are opponents and who support organ transplantation, but we have to move forward so that we think that if it is like permissible. So when we look at their arguments who accept the organ transplantation, the first argument is necessity, because they claim that touching the human body, whether he is alive or dead, is impermissible. This is a general rule coming from the scriptural understanding and classical fiqh books. So they agreed on it. Even they reject organ transplantation or accept. These two groups are they agreed on the opinion of this idea actually. So they don't say human body is not doesn't have any dignity or something, but who accept the organ transplantation, they give emphasis to the receiver, but the other part is to the donor. So they say that there's a contradiction here. There is a dilemma actually between protecting one's body and protecting one's life or health. So there's a huge dilemma here. So the other thing might be ethar, the understanding of ethar, which is altruism. So the question of whether can I donate my organs, making this altruism, because I don't have any necessity from the donor perspective. Okay, receiver in a necessity situation, but the other one is not. So the ethar altruism problem is coming here. So a lot of questions, I don't know how to answer all. So maybe as a general, Dr. Samir's critics was related to the using classical books for today's issue, right? Maybe the basic thing. So I think when we look at the classical books, they have more deep and maybe more critic understanding, even today's ulama, I guess. I both search the classical books and today's opinion, and I found that they are like more theological, they have more theological and fiqh basis on it. So they put the understanding of contracts, transactions, saying that it is not al-mal, it is not mal al-mutakawim because of these reasons. So I think we should benefit from this tradition, and we should inherit it. Of course, we don't have to accept directly, but we should benefit from these understandings. So relating to analogies in the fiqh books, like selling mother milk, of course we shouldn't take it directly, but we can ask this question: would Hanafis, for example, live today? Would they accept the selling or buying organs, because they rejected selling human milk? So maybe Shafis or Malikis would think in that way. They said we benefit from them and there's a necessity, so let's use human organs. My claim was not let's read and take directly, etc. Just benefit from their understanding. So the other one is, yeah, actually for all kinds of organ transplantation there should be necessity. But we have some organs like a face, arm, leg. So actually, can we put them in the concept of necessity? We are not sure about it. So women, people can live without. There are some alternatives, I mean, for face, for arms. So they are not crucial for life. So the concept of necessity is only for the situation if you lose your life or health directly. So actually there is a lot of ethical discussions regarding this, in the West even they say it's a kind of experiment on human body. because there is no real necessity. So to donate for kidney, for heart, for pancreas, maybe for necessity, there is no another option, but there is an alternative here. Similarly, womb transplantation for women, or maybe in the near future we will talk about what is the name? Transgender people, can they have womb or sexual organs? These are not all about necessity. Yeah, if there's a necessity, I think the issue should be different. If there is no, we should discuss all types of organ one by one. So I don't want to. Yeah, thank you.
Thank you for the questions again. Starting with Taha Abdurrahman's terms, I think the three categories are al-karama al-taqdiriyya, and I translated that as initiative dignity. The second one is al-karama al-taklifiyya, and I translated that as evaluative dignity. And the third one is al-karama al-tafdiliyya, and I translated that as superlative dignity. Now, about the other point you raised about whether and to what extent patients, especially at end-of-life situations, can choose to refuse treatment, medical treatment. I think that depends. That depends on several factors. First of all, it depends on the outlook of the patient himself or herself, right, and his own attitude or opinion, his religious, moral, theological kind of background and personal conviction, right? But also on his situation, medical situation, and which is quite subjective sometimes. It is based also on his opinion, how he feels about himself, but also what other treating physicians, for example, or experts say about this case or this situation, whether there is available treatment or not, right? So as you can see, the issue is not easy, but I think in the literature, oftentimes you come across this notion that these kinds of situations have to be addressed on a case-by-case kind of basis. But in the bioethical literature, there is a topic called treatment refusal. And this is very much addressed in a way, that aims ultimately to procure the maximum benefit of the patient, given the situation, if that makes sense. Now, about Dr. Samer Rashwani raised several issues about use or utility of the classical fiqh discourses, right? I think again it depends here on how you deal with it. Whether you just follow it blindly, you just go and copy what these other pre-modern jurists are saying about similar situations or about cases, or whether you are looking at the logic, underlying logic, in these kinds of cases. And here I think classical fiqh can be very useful tool, even in just learning how these jurists made these kinds of arguments, keeping in mind what you said about prudential, what you call prudential fiqh, right? So actually there are several ingenious kind of insights that can be gained from these discussions. And anybody who had, I would say, a superficial familiarity with this discourse would be impressed by how deep and how sophisticated actually sometimes these discussions, even in shuruh and commentaries and super commentaries, etc. So for example, they talked about, again, going back to the question of whether abortion can be done in order to save the mother, the pregnant women, for example, and they discussed that and said that if the mother dies and somehow they detect movement in her belly or her womb, which indicates that the baby or the fetus is still alive, the question was whether they should cut the belly open, right, in order to extract the living fetus, or let it die and be buried with the woman. I think the majority kind of sided with the view that yes, you can cut open the belly of the mother in order to save the living fetus. And here you can see these competing interests, right? And they sided again with the principle of life, right? they recognized that that will involve some sort of acting against, the principle of sanctity of the human body, right? But still, they said that this is enough grounds or justification in order to achieve a higher kind of good. So again, they engage in this kind of moral calculation, which is very interesting. Another similar case, which we can refer to as some people refer to this as paradigmatic cases, that you don't follow them, but you just study them in order to see the underlying logic. If someone swallows something precious, a piece of jewelry, for example, and then ends up dying, what do? Do you cut the belly open in order to extract that? Especially, if it belongs to someone else, right? Or, just bury the individual with that precious item. Again, it is very interesting to see the discussion there. So again, this can be useful, not to follow it blindly or literally, but just to learn about how they thought about these kinds of issues. And then you can extract, this kind of logic or use it in contemporary kind of cases. You mentioned necessity and whether invocation of necessity is always bad or always good. And I don't think it is wise to paint with this broad kind of brush, that it's always bad or always good. It really depends, right? And I think world, due to something that has to be traced back to the early modern, the past 200 years with this duality, of law and Islamic law, right? Legal, positive, state law, and fiqh. For the longer part of Islamic history, fiqh or Sharia was actually not just a theoretical kind of system, but also an applied system, right? Now, in the modern period, we have this kind of duality. Sharia was set aside, Western law was introduced, and then this duality was created. And one of them is this notion of necessity, because the juristic discourse was relegated, pushed to the side, right? So legally speaking, when you go to the court, things or issues are settled according to the law, legislation, that is secular state law, right? But still people continue to go to the muftis to ask about, whether it's halal or haram, right? Now they are not in charge of the courts, right? But because legislation or the state of Islamic law somehow lagged behind because of this realistic kind of situation, empirical reality, right? Now they fill back on these legal tools, right? Maslaha and necessity, right? Simply, which I see or attribute to this lack of power, basically. You don't have power to enact laws or to legislate. What they are left with is, to act on the moral plane, right? And depending on the situation, they would fall back on these tools that would allow them to deal with these kinds of day-to-day issues, problems, etc. And I think when you mention slippery slope argument or logic, it's sort of answers the first part of your question, because whether we need all the time to demarcate necessity, I think we do, in order to distinguish between what is the norm and what is the exception. In this case, if you lay to rest this kind of distinction, then before you know it, people can engage in organ trafficking, right? If you open the door for organ sale, it can actually develop into organ trafficking. So whereas you need actually some sort of criteria to go with or to implement, what is the norm and what is the exception, right? So I think sometimes this is useful and helpful. You mentioned the issue of, this kind of underlying reasoning and how these Jews thought about these issues and to what extent they relied on scriptural, textual sources, tools, or additional tools. And I think that brings us to, this history of Islamic legislation, right? And especially in Usul al-Fiqh, where we see it is a story of this interaction between reason and revelation, right? Yes, you rely on the foundational text, but in order to interpret them, let alone implement them. You need reason, right? This interaction between the text and social reality, after all, fiqh was not just this isolated, abstract, theoretical system. It was very much also the law of the land, if you will, or at least the foundation of that, right? So jurists, in order to bring up effective solutions, they needed to know how society worked, right? So especially in the area of transactions, right? Sale and all types of transactions. But otherwise, other sections of the law or fiqh as well, they require very much, in addition to the theoretical knowledge of the scripture, of the tradition, very much also knowledge of الواقع, reality, in order to engage with it, right? Otherwise, solutions will not be practical, won't be effective, if that makes sense.
And so I have to apologize for those who still had questions, but we started half an hour late and we ended more than half an hour after the due time. It's a testimony to the quality and of the papers, the kind of sustained interest that they have received from this audience. But I think there's opportunities to continue the discussion more informally next door. So maybe the organizers can tell us.
Thank you so much, Dr. Alexander. So we're gonna stop now for a lunch break, and we will come back by 1:30. But before the lunch break, I would kindly ask the speakers for a group photo. The photographer will be here. If you please don't mind, line up next to the podium, and we will take a group photo. Thank you. Assalamu alaikum. Welcome back. I hope you enjoyed your lunch break. I just want to inform you that we will have a tour in the building, in this beautiful building, at 3:45. So please, my colleague Sulaiman from the Education City Mosque will be here to take you into the tour at 3:45. We'll now proceed to the last session of the day, moderated by Dr. Mu'taz Al-Khatib. He is a professor of methodology and ethics at the Research Center for Islamic Legislation and Ethics at Hamad bin Khalifa University. Dr. Mu'taz Al-Khatib, the floor is yours.
Thank you very much, Rowan. Welcome back. Assalamu alaikum wa rahmatullah. So this is the 5th session in this conference. And in this session, we have 2 papers. The first one is going to be presented by Dr. Mu'taz Al-Fujairi, and the second one is going to be presented by Dr. Ray Juradini. As for the first one, it's entitled Maqasid al-Sharia, Human Rights and Judicial Ijtihad under Islamic Constitutionalism, the Supreme Constitutional Court in Egypt. Dr. Al-Fujairi was a senior teaching fellow of law at the School of Oriental and African Studies, SOAS, at University of London, and he's currently the head of Human Rights Program at Doha Institute. He's going to talk about Maqasid Sharia and human rights as I mentioned, in the judicial ijtihad under Islamic constitutionalism. Dr. Mu'taz, the floor is yours. So you have 30 minutes.
Thank you very much, Dr. Mu'taz, and a great pleasure to be here with you among a group of distinguished scholars. Well, my contribution will look at the interplay between Islamic ethics, constitutional rights, and human rights in the work of the Supreme Constitutional Court in Egypt. So my general proposition in this presentation is that Islamic constitutionalism can provide a legal space for the interdependence and mutual learning between Islamic ethics, and here I'm focusing mainly on the concept of Maqasid al-Sharia, and constitutional rights and international human rights. You know, since Arab Spring, there has been much debate on the role of Islam in the constitutional and legal system, and this issue was somehow dividing in some of the political transition in the region. We have seen what happened in Egypt in 2013, and the debate also in Tunisia. So I am going in this presentation to look at things from different way, not to see Islamic constitutionalism as a threat, but also to see Islamic constitutionalism in a way that could harmonize Islamic law or Islamic ethics and constitutional rights. And this will be clear or applied to the work of the Supreme Constitutional Court, and also I will discuss the limitations in the case law, because I believe that this case law can develop. There has been increasing attention in recent debates to the theory of the goals and purposes of Sharia, Maqasid al-Sharia, and its potentiality to ensure the flexibility and adaptability of the incorporation of Islamic law in the legal system of Muslim states. Vast literature on that, theoretical literature. My purpose here is to contextualize this debate. So we need to look what's going on in practice in Muslim and Arab legal system, and how mainly the judiciary here could consider this theory in producing evolving or evolutional jurisprudence on rights. And as I said, the intersection between Islam, constitutions, and legal system continue to be a legal reality in many Arab and Muslim states. Egypt is a case in point in this regard. Given the place of Islamic law in the legal system, the active rule of the Constitutional Court is one of the most active constitutional court in the Arab and Muslim country. It has rich case law, as I will show now. and also the increasing judicialization of religion, litigation on religion is very active in different courts, not just the Supreme Constitutional Court, but also before the Administrative Court and Family Court. And the intensive litigation on Article 2 of the Constitution, which define or prescribe Islamic law or principle of Islamic law as the principal source of legislation. And Egypt also ratified key international human rights treaties and made reservation on the ground of Islamic law. Well, looking at the question of Islamic constitutionalism, some scholars argue that Islamic constitutionalism find precedent and justification in Islamic history and legal tradition, and they view it as an indigenous expression of collective identity and instrumental for rule of law and political accountability in the Muslim world. There are another trend in the literature which question the conceptual, historical, and political legal origins, and also highlight the contradictions and limitation of Islamic constitutionalism. In my presentation, I am not questioning the concept of Islamic constitutionalism or the place of Islamic law in the legal system. My purpose here is to explore the mechanism under which harmonization could be established between, some kind of harmonization could be established between Islamic law and human rights. So, I mean, this debate is very important, but it is not now the reality in most Muslim states and Arab states that there is some kind of intersection between Islamic law and the legal system. So I would like to see in practice how this works and what are the conditions or the mechanism that could develop a healthy relationship between both. I hear, for example, cite Ahmed and Ginsberg in their important article in 2014, which they published following the Arab Spring. They say that the co-occurrence of rights and the Islamization in Muslim constitution, according to them, highlights the important role of the Constitutional Court and other bodies entrusted with the interpretation of constitutional rights and the Islamic law. They added that the project of balancing right and Islam cannot but be resolved in each country through its own political and judicial processes. So the role of judiciary and the constitutional review in Muslim state is instrumental to mediate between Islamic ethics and human rights. So the paper approach the role of local actors, court in this regard, in translating international human rights in local cultural context through Islamic ethics. So this is what I'm going to explore. Constitutional review itself is evolving in the Arab region. It's still evolving slowly because there are constitutional courts established in many countries following the Arab Spring, but the case law is very limited. So Egypt here is exceptional situation or exceptional example, and I will show you here. For example, this is my sources which I depended on in this paper. So for example, before the establishment of Supreme Constitutional Court, we had the Supreme Court. It examined 3 cases which mention Sharia. Supreme Constitutional Court decided on 135 cases which deal with Sharia under the 1971 Constitution, 2012, 2014. So this is rich material to look how court interpret Sharia and how they use Islamic ethics in their interpretation. So this is a classification of cases. So we'll see here many important topics like polygamy, divorce, khula, redemption, maintenance, obedience, child custody, guardianship, wilaya after divorce over children, marriage registration, woman dress, gender equality in nationality law, marriage to foreigners, right to marry, economic and social rights of women, empowerment of women, appointment of women in public positions, religious freedom, equality between Muslim and non-Muslims, bequest to heirs and the revocation of hiba, al-wasiyya wal-hiba, Islamic criminal law. There are lots of cases that provide us now with rich source to explore the role of the court and how Islamic ethics interplay with constitutional right. Of course, there is vast literature on the Supreme Constitutional Court. My contribution here, looking at the cases over the last 10 years following the Arab Spring, but also my lens is different because I'm looking from the perspective of Islamic ethics, human rights, constitutional rights. I'm not going just to look at the role of the court, because the literature focused mainly on how the court contained Article 2 in the Constitution, the role of the court to contain Article 2. This is not my perspective. My perspective, how Islamic constitutionalism in Egypt worked in practice to harmonize between Sharia and human rights. So these are the main argument. My argument here is that Maqasid reasoning has allowed the court to a greater degree to read the constitutional text in a harmonious manner, where Islamic ethics and constitutional rights reinforce each other. This is very important, and we will explain now the cases that prove this. The reference to Maqasid in the court Islamic legal theory has enabled it to legitimize, in Islamic term, key reform, particularly in the area of rights of women. And the court was very active in this regard. The evolution, the institutional history of the family law in Egypt cannot be understood without looking at the court, the role of the court. Because in each historical moment, the court defended the reform taken in the personal status law, but from an Islamic perspective. This is very important in terms of legitimation of the family law, or the reform taken in the family law. The court has also utilized Maqasid reasoning in its response to emerging constitutional litigation, which invoked Islamic law in conjunction with constitutional rights and human rights. And this trend is less covered in the literature. This is a very important trend. Litigants themselves use Islamic or Islamic constitutional provision in conjunction with constitutional rights, human rights, to challenge unjust law. This is a trend that very growing in the work of the Supreme Constitutional Court, and it enabled the court actually to develop the law, to strike down some laws and develop the law by its reasoning. And finally, I argue also that by mainstreaming the use of Maqasid in its Islamic legal theory, the court can accumulate dynamic and evolutionary Islamic jurisprudence on rights without being constrained by the dominant views of Muslim jurists. And this is the critique that I'm going to do on the case law, because I think the court could develop its theory further, looking at the comparative legal practice in the Arab region, especially in Tunisia and Morocco, when it comes to gender equality. Okay, we will start first here by looking at, but very quickly because I need to jump to the case law, the interplay between Islamic ethics and human rights in Muslim state practice. So I'm like here to just explain the theoretical conception where I am in this debate. So as I said, there is contemporary literature on Maqasid al-Sharia is vast in the Arab region and outside the Arab region. And there are lots of sources on that which deal with the concept from a theoretical perspective. But we are concerned here about how this theory work in practice. So there is, of course, an important contribution provided by Professor Mashhood on the role of Islamic ethics in the harmonization between Islamic law and the international human rights law by using Maqasid, Maslaha, Takhayyur, and he proved very well in his work that there are possibilities, there are theoretical possibilities that Muslim court can use in order to develop what he called evolutional interpretation of Islamic law. This literature shows how the theory of Maqasid underlines common ethics and purposes shared by Sharia and human rights. According to this view, the overall purposes of Sharia should always be kept in mind when interpreting Islamic sources and applying Islamic law. And this is what I call Maqasid reasoning. When reading Islamic sources, this need to be kept in mind and it will affect the outcomes of the interpretation or ijtihad. A trend in the literature examine the role of court in Muslim state and what so-called collective or judicial ijtihad. This term actually evolved in Pakistan. Literature on Pakistani Sharia, federal Sharia court, and how it worked to develop the law in Pakistan. There is very important literature produced on the work of the Sharia court in Pakistan. And also Muslim court engagement with Islamic law, not containing Islamic law, because as I said, in the early literature, scholars were concerned about how Muslim court in the Muslim world contain Islamic law and secularize the law. But there is another trend Intisar al-Rab actually argued that no, this court engage with Islamic law, not just to contain Islamic law, but engage with Islamic law in order to develop the practice of constitutional right and human rights. And of course, here some examples in the Arab region. We see that things are changing over the last decades. Of course, the family code in Morocco, 2004, cited Maqasid al-Sharia in the preamble. So it was used in the interpretation of Islamic sources. Arab Charter of Human Rights, 2004, also indicates some change in how government in the region also look at the place of Sharia in this kind of instrument. Al-Azhar document on human rights and rights of women in 2011, there are also important documents published by Al-Azhar. Revised OIC Declaration on Human Rights in Islam, which published in 2021. It's entirely different from the OIC Declaration published in 1990. And there is also another important document, the government-sponsored report on equality and personal liberties in Tunisia, which was published in June 2018. In some section of this report, it also used the theory of Maqasid, and they also proposed some kind of new reform in the Muslim family law. Of course, many Muslim scholars may have different views on the style of ijtihad in this report, but the reality is that the practice under Maqasid reasoning, as well as the interplay between the text and the Maqasid Maslaha, is diverse. Yani we don't have one approach. There are different approaches. We have Yusuf al-Qaradawi approach, Ahmed al-Raisuni, Muhammad Hashim Kamali. So it is not just one trend. Within the Maqasidi literature, there are lots of trends which justify, for example, the radical reform taken in Morocco, justify the debate right now in Tunisia on equality, on inheritance, and it can also justify some partial reform taken in Egypt. So this is the reality. So just quickly, incorporation of Islamic law and the human rights in Egypt legal system. Before examining how the court interpret Islamic ethics and human rights, we need first to understand how Islamic law incorporated. I think it will impact. It will impact how court approach this question. So we have Article 2 is very embedded in Egyptian constitution since 1971. And that's why when I started my presentation, I said I'm not taking a position on Islamic constitutionalism, because regardless of the theoretical position, this article is embedded, and there were lots of attempts to remove it. It didn't work, it didn't succeed. So usually this article, it can be included in the constitution in a political setting, but to amend it, it's much more difficult. And we have seen that in Egypt. So the idea here is how to work within this model. Other religiously inspired constitutional provisions. And this is here important. I have to show you this table, because it is not just about Article 2. Islamic ethics can be found here in Article 10. I'm talking here about 2014 Constitution. Article 10, family is the basis of society and is based on religion, morality, and patriotism. The state protects its cohesion and stability and the consolidation of its values. Then Article 11, on gender equality in accordance with the Constitution, here reference to Article 2, most likely this is the intention. Reconciliation between women's duties in the family and her work in society, protection of motherhood, childhood, breadwinning, and elderly women. Well, human rights defender looking at this article, they will just come to the conclusion that this will be restrict. This will restrict human rights. But I found in the case law different approach. I found in the case law that this article were crucial for the court to provide affirmative action for women and to empower women in public position and to justify certain empowerment of women in public and in family as well. So yes, it can be used to restrict, but also this cannot ignore that that the court can also use them in a progressive way. In 2014 also we have for religious freedom. So yesterday we were talking about monotheistic religion and how the Constitutional Court in 1975 fused between public order and Islamic law and just defined that only three Abrahamic religion have the right. 2014 now constitutionalized this principle. So it is now constitutionalized. So no way. I mean, there will be no reasoning. Now it is in the hand of politician and the parliament to amend the constitution. But this principle started first from the court, then it became part of the constitution. So this is also the limitation right now working in the court. The theory of the Supreme Constitutional Court. This is the theory of the Supreme Constitutional Court. Lots of articles written about that. I will just explain very quickly. We have the non-retroactivity principle. So any laws published before 1980 will not be examined by the court. Differentiation between certain and ambiguous ruling of Islamic law. This is very important because I'm going to critique the court, how the court used this principle in its case law. Certain rulings are universal and ambiguous rulings are susceptible to independent reasoning. So certain rulings, according to the court, they are universal, they are eternal. No ijtihad can be practiced on them. Well, the idea is not to identify certain ruling. Of course, there are certain ruling, but which certain rulings the court identified? Because I believe that the court expanded a little bit in some certain rulings that are not being treated like that in other countries. Universal ruling are those derived from clear text in terms of meaning and authenticity. أحكام قطعية المعنى أو الدلالة والمصدر يعني. Ijtihad should be consistent with the general objective of Sharia and the doctrine of public interest. And this is flexible and subjective element, but it's flexible because in the practice of the court, so other text, other constitutional provision will be harmonized with Article 2. There is no hierarchy here. I mean, once the court identifies certain ruling as presumptive, so now, I mean, everything could happen. I mean, you can invite international human rights law, you can invite constitutional right. So the problem is whether the ruling will be certain or presumptive. And many human rights provision could perhaps intersect with the certain ruling in the case of Egypt, as I will explain. And then the universal ruling of Islamic law enjoy hierarchy over other constitutional principles. Now I need to look at very quickly to the case law, to just give example here. So I will explain two trends in the case law. The first trend, the reference to maqasid in the court Islamic legal theory has enabled it to legitimize in Islamic term key legal reform in the area of rights of women. We have, as I said, rich case law on personal status law reform in the area of divorce, registration of divorce, registration also of revocation of divorce, polygamy, divorce for harm on the basis of polygamy within 1 year, maintenance, wife, obedience, custody, and guardianship. Special measure to guarantee the appointment of women in certain public position, family court, rights of children. Let's take one example of these cases, which is, I chose a recent case on guardianship, al-wilaya. How long is the time? Okay. Al-wilaya. This is one of the important case after divorce. Usually, I mean, in Egypt law, wilaya or guardianship over children is the right of father. But the court has changed that because the legislation was amended to provide women educational wilaya over children. Some litigant challenged the constitutionality of that. So the court defended the position, saying that first, the court established that there is no clear ruling in Islamic law on the educational guardianship and that the issue has been a source of disagreement among contemporary Muslim jurists. The court here referred to the best interest of the child and to consider this also part of the Islamic ethics, and argued that women have the has the responsibility to bring up their children and to avoid any practical obstacles that could undermine the child educational life. She has to also control the educational wilaya. So this is very important. I see in some other countries it is very minor reform, because in Tunisia, for example, wilaya is jointly practiced by father and mother. But in Egypt it is important because for many years some men trying to control and pressure their wife using their wilaya over education. The second trend in the literature, how the court developed the law. And here I chose developed the law by using Islamic ethics and maqasid reasoning. So here there is a very interesting case, and the use of Islamic ethics is very clear in this case. The development of the custody law, connection between grandparent and grandchildren. I think this debate also happening in European Court of Human Rights. So what's the court said? The court held that grandparents have the right to regularly see and spend time with their grandchildren when the parents are divorced. The personal status law was granting this right only when parents are not present, when parents are absent. Some litigants challenged the constitutionality of that. The court said that the law is inconsistent with Islamic Sharia because it fails to maintain the ties of kinship, Silat al-Rahm, and protect the family ties. The law did not consider the interest of children and their relationship with the grandparent, and did not respond to the feeling and emotion of the grandparent and their need to be connected with their grandchildren. Yeah, just I did a research on the European Court, and I found that this debate existed also in the case law of the European Court. I mean, the right of parent toward their grandchildren. But this is important in Egypt context, and the law was changed, of course, after this ruling. Just to jump quickly to the limitation, because it's very important to also highlight why there are some problem in this. We have one of the problem here, as I said in the beginning, that the court declared some ruling as definite and universal Islamic ruling that cannot be subjected to ijtihad. What are these rulings? For example, unilateral oral divorce by men, wife obedience, polygamy, men power of guardianship over children except educational guardianship. So the court declared this as universal rule. This will limit the ijtihad on this area, and it will also limit the litigation, and it will affect on all Egyptian court. I think the court was not, I think it could have different conclusion if the court actually engaged in a fresh interpretation of the Islamic sources which govern this ruling without being limited to the majority of views of Muslim jurists, classic Muslim jurists. And we have the model in Morocco. So according to this list of ruling, Muslim family law in Egypt will not be able to be amended like the family code in Morocco. For example, Professor Mashoud in his book, he was proposing that divorce could be validated by the court, and this could be justified under the principle of maslaha and principle of hizbah, because men misuse the power of divorce, but the court will disagree with that. Now the court, it considers that the oral divorce by men, unilateral divorce, is universal Islamic ruling. So this is the problem right now. Another problem also related to, and this is one of the problems that I will conclude with, related to the structure of Sharia in Egypt law. Many important cases are not reached or have not reached the Constitutional Court. Why? Because the personal status law in Egypt gives discretionary power to judge in lower court to refer directly to the school of Hanafi school of law, if the law is silent on a specific issue. And court in judging in lower court use this power to develop legal provisions that do not exist in the law. For example, civil consequences of apostasy, limitation on custody of non-Muslim women who were divorced from Muslim men, and this is important in Egypt because we have a large segment of the population are Christian, and there is interfaith marriage, prohibition of interfaith marriage. So the idea here is that these issues have not reached the Supreme Constitutional Court. I think that the law in Egypt, the problem of the law in Egypt, that it limits judges to look at the Hanafi school of law only, the prevalent view of the Hanafi school of law. In other Muslim countries, it allows judge to look at any school of law or to ijtihad, mainly directly based on the principle of Islamic law. But right now, it's like transforming the Hanafi school of law to positive law. It became like positive law. So judge will only look at the prevalent view of the Hanafi school of law in order to decide on these issues. Only in 2009, the Court of Cassation, Mahkamat al-Naqd in Egypt, did some changes in the interpretation of the Hanafi school of law when it comes to custody right of non-Muslim divorced from Muslim men. The court raised the age of children to 15. So it achieved some equality between Muslim and non-Muslim. So it presented a new interpretation of the Hanafi school of law. But I think this battle, this judicial battle, first of all, it is being happened away from the Supreme Constitutional Court. Second, it is limited only to the Hanafi school of law. So it limits the ijtihad that can be practiced by judge. To conclude, so these are I think that the Supreme Constitutional Court provide a case study of how Islamic constitutionalism can be a space for the interplay between Islamic ethics and human rights. Maqasid reasoning provide for a harmonious reading of constitutional provision on Sharia in conjunction with constitutional right provision. Both can reinforce each other. Under this evolutional approach, Islamic constitutional provision will not be seen as a threat to constitutional human rights, but will be constitutional right or human rights, but will be a catalyst for a proactive constitutional litigation that invoke Islamic ethics together with human rights to challenge unjust law. And finally, institutional and political context of court. And the constitutional review is very important in this regard because, first of all, the judicial independence, especially since 2013, we have, the political power and the military started also to control the Supreme Constitutional Court. And this will affect the credibility of the court. It's very important. The credibility of the court when it comes to being an authoritarian arbiter on Islamic law, this body needs to have credibility before the public. Second point, the coordination between the court and jurists, Muslim jurists. I think this needs to be also somehow reformed. Right now, usually the Supreme Constitutional Court listens to Al-Azhar. It cannot challenge Al-Azhar. Most of the cases, it listens to the debate in Al-Azhar. But I think in this type of Islamic constitutionalism, it is important to include in some way or another some Muslim jurists in the process in order to empower the court and also to achieve legitimacy of the outcome. This is very important, to achieve legitimacy and sustainability of the outcome of the court, and also encourage the court to practice ijtihad, because I felt in the case law that the court reluctant. And why they are reluctant? They're reluctant to present fresh interpretation of Islamic texts. They usually refer to the majority views of Muslim jurists. And this is very conservative, and the development will happen very slowly if the majority towards certain issues has changed. So I think the court needs to be empowered to practice what I call judicial ijtihad. Thank you very much.
Thank you, Dr. Mu'taz, for sticking with the time and for this interesting presentation. Now I will move the word to Professor Ray Giardini. Dr. Ray Giardini is the professor of Migration, Human Rights, and Ethics at CILE, and also in the program of the MA program in Applied Islamic Ethics. He published several books and articles, and he's going to talk about human rights and relativism. So the floor is yours, Dr. Ray.
Thank you very much. My presentation today is going to be a bit more unusual than the other papers. I was asked to present something specifically on migrant workers and human rights, and as you all, I'm sure, are very aware, that's been a major focus of debate in Qatar and around the world, with a lot of hand-wringing and gnashing of teeth over the last decade since the World Cup was announced to be in Qatar in 2022. Accusations of corruption in the bidding process and poor conditions of migrant workers were unrelenting, some justified, some not. The debates that ensued were primarily secular. There were no references to Islamic ethics and law that came into these debates, except for some of the work that we did in CILE. Now, for today, I decided to talk about an article that adds another dimension to the critique of human rights, the idea of relativism as pitted traditional terms to human rights. And so it's going to be very much a micro analysis of this critique. It was a critique that was written from some scholars in Bangladesh in relation to the human rights analyses and reports about the conditions of migrant workers in Qatar, and they were specifically referring to the migration of Bangladesh workers from Bangladesh to Qatar. The article was published in 2017. Most of the authors, I think, were anthropologists working with a particular research organization in Dhaka. The questioning was rather passionate, and I hope that I can do some justice to the nuances that are presented, and that this can reveal some interesting issues. Well, to begin with, in the social sciences, much has been written about the contradiction or the tension between cultural relativism and ethnocentrism. Cultural relativists take the view that values are defined by the local culture and should be evaluated only from each culture's perspective. By contrast, ethnocentrism is the evaluation of other cultures based upon one's own values and customs. Generally, the social sciences have insisted, at least since the turn of the 20th century, insisted upon taking a cultural relativist position, at least partly to avoid imperial or racist positions that may be located in extreme applications of ethnocentrism. Well, human rights are akin to an ethnocentric perspective because they have been formulated in universalistic terms, like the Universal Declaration of Human Rights. And much is to be learned and understood from cultural relativist positions and deep contextual understanding of different cultural beliefs and practices, typically as in ethnographic methods and analyses in anthropology. It's argued, however, that this is not compatible with human rights concerns and perspectives which were established as universal standards in order to transcend disparate cultures and nation states. Indeed, as the sociologist Brian Turner puts it, cultural relativism undermines the universalism of human rights legislation. And in this sense, he argues that the core of the sociological contribution has been the study of social rather than human rights. Sociology has been unable to problematize the possibility of a universal system of human rights in the face of deep-seated cultural diversity and specificity. This tension or dichotomy is a constant issue of concern in the human rights discourse, as we've seen already in this conference and elsewhere. The idea of universality versus relativism, or as Dr. Mashoud put it, universality versus the particular. And as Dr. Rashwani pointed out, philosophers such as Michael Sandel, Charles Taylor, Amartya Sen contend that the human rights approach not only undermines but also operates against a range of other morally significant human relationships and attitudes. These include community, solidarity, care, compassion, and benevolence, all of which play an essential role in our lives. And typically these issues are articulated, as you will see, in the Bangladesh critique that I will elaborate on. But before going on, I need to explain what is the migrant labour recruitment process in my analysis. I'll do this very briefly, although it's simple yet it's complicated. My argument is that there are three levels of competition in the migrant labour process. The first level is where private companies compete with one another to get, in a tendering process, to get contracts to do projects of various kinds. Right, so that's one competitive dimension. The second is that once the contract has been obtained, then they need to bring in, I'm talking about Qatar, they need to bring in migrant workers in order to do the work. And therefore, they need private recruitment agencies in the countries of origin to bring them over, to select and bring them over here. And so there's a competition between the private recruitment agencies to get what we call the labour supply contract. And thirdly is the competition within the workforce, competition between workers, people in countries of origin vying for these jobs against one another. And the labour demand, that is the demand, the requirement for labour, actually begins in that tendering process before a project is even allocated to a company to fulfill. And in that tendering process, companies want to minimize the cost of the project in order to be more competitive. So they want to bid at the lowest amount in their budget that they can in order to maximize their chance of getting that contract. That is when the judgment as to who's going to get the contract is based upon the lowest bid, right? Now, one of the ways in which companies reduce their budget is by not paying for the costs of recruiting the migrant workers from their countries into Qatar. This is the same scenario for all of the Gulf states, as well as many other countries as well. And so, in other words, they require others to pay the costs of the recruitment. And what has actually developed because of that, what's developed is what's called the worker pays model. That is, the costs of the recruitment are paid for by the worker rather than the employer. This is only for the low-skilled, low-income workers from Asian and South Asian countries. Skilled professionals do not pay as these workers pay. So the worker pays model is also seen as providing a distortion in the labour market, because the workers are selected on not just the standard principles of being competent, having the skills, experience, and so on and so forth, but also they're selected on the basis of their ability and their willingness to pay the money for the job. Now, this allows for deception in wage levels, what we call substitute contracts, where a worker may sign a contract in their country of origin and they arrive here and they're given another contract which is less beneficial. And they have played around with all sorts of things like food allowances, etc. Now, workers who have to pay this money, and it can range from, $500 to $5,000. I won't go into why there are those differences, but I can if you're particularly interested. But what it does is that workers have to borrow that money in order to pay it. Often they may go to loan sharks and borrow money at very high interest rates, up to 60 or 70%, which is against Islamic principles, financial principles. But it also leads to forced labour and trafficking and what has come to be known as modern-day slavery. It's because of this particular set of arrangements in the recruitment process and the fact that workers have to pay, coupled with the kafala system that has been operating in this region. And let me just give you an example. When I was first interviewing workers in Qatar some 10 or more years ago, I would ask them, are you receiving the salary that you were promised before you left your country? No. Oh, did you talk to your employer about that? Yes. So what did your employer say? Well, he said, if you don't like it, you can go home. Now, that's in the context of the employer knowing that they are in debt and that they cannot go back because they have to earn the money sufficient in the first instance to repay that debt. Okay. Now, what that does is it creates a captured workforce, and indeed that is a form of forced labor. Okay, but what it did do, from the point of view of the country, is it created stability, tremendous control and stability over the workforce, which has been maintained pretty much until the World Cup, which is now over. Because if workers are in debt, they're much less likely to leave. But it was also in the context of pre-reforms in Qatar, where we had what was called an exit visa. All of us who have been here for some years were also bound by the requirement that you needed your employer to improve, to allow you to leave the country whenever you wanted to leave the country. We used to have to rush over to the Qatar Foundation administrative offices to arrange these exit visas before we could leave. And the last point here I wanted to make is that these circumstances and controls also feeds corruption. The large amounts of money that these workers pay is far in excess of what the actual costs of recruitment are. And so there is this surplus of what the workers are actually paying, and some of that surplus goes to pay people in the employing company in Qatar, and in other Gulf states, in the countries of destination. That's what we call kickback bribes or kickback payments. To give you one example, one human resource manager in a corporation was receiving $500,000 each year just in these kickback payments, because he is the one who is choosing which recruitment agency is going to get the contract to supply the labor, right? So that's a lot of money that they're getting surreptitiously in the form of bribes or exaction, depending on who's actually asking for the arrangement. When I was doing my research, I was offered bribes. So I know directly, because they thought that I was doing research in order to provide a labour supply contract. And so I was offered these bribes. It's a lot of money. I asked the guy, I said, well, what if I give you a contract for 30 workers, to bring in 30 workers? He said, we'll give you $400. I said, what about if I give you a contract for 100 workers? He said, we could make that $600. That's per worker, right? So what that means is that for a contract for 100 workers, he would give me $60,000 in cash with no paperwork involved. Okay, so this is a very, very large amount of money. Goes into the billions of dollars collectively, and so it's a very powerful motivator. So what has developed over the decades is that a culture of corruption. That is, employers expect that the workers will pay, and workers expect that they will have to pay. And that is what the system has been feeding on, despite legislation in 4 of the GCC countries prohibiting workers being charged for recruitment costs. And an ILO Convention 181 also makes it clear that employment agencies should not charge directly or indirectly, in whole or in part, any fees or costs to workers. The same is said in the Qatar labour law. Article 33 says the same thing. Also in the United Nations Global Compact on Migration, again, prohibiting workers being charged. Nonetheless, the system continues unabated. Okay, so you may have many questions about this analysis, but let's go to the critique from Bangladesh. I'm sorry, I thought I had a really short paper. In this case, this group of scholars argued that human rights researchers observe and analyze the migrant recruitment process as outsiders. In other words, they're outside of the country, they're not from Bangladesh, they move in, they do their analysis, and then they leave. And these outsiders falsely blame and demonize the local recruitment agents for misleading and illegally charging prospective migrants. And secondly, they characterize migrant workers as victims without giving them a voice or understanding the cultural context of their recruitment and placement for jobs abroad. The article argued the following. They take a relativist, or what they will call an emic perspective or internalist perspective on how migrants view recruitment as distinct from the way in which it's conceptualized by the outsiders. In theorizing our findings, they say we draw on the recent literature on brokerage, which focuses on the social relationships that underpin the contract between migrants and agents. Ethnographies of the relationship between them have delved deeper into social bonds of trust, how these are forged, and what recourse migrants have if promises are not kept. The exploitation and risks, they argue, faced by migrants should be viewed against the risk and vulnerabilities that aspiring migrants would face at home in a context of extreme poverty and a lack of well-paid work. While outsiders measure the success or failure of migration against the yardstick of decent work, labour laws and personal freedom, migrants themselves have in mind long-term goals of self-development and advancement of their families. Brokers are indispensable in achieving this goal. In the moral discourse of migrant welfare and humanitarian approaches within government, NGOs, researchers and aid agencies, brokers are portrayed as powerful and unscrupulous individuals who exploit defenseless migrants. Migrants are the victims in this discourse, and brokers are accused of deceiving them with false promises, charging exorbitant and illegal fees, trapping them in debt, switching jobs, and confiscating their passports, making it virtually impossible for the migrants to turn back and to escape. They further argue, and I quote, a report on migrant labour recruitment in Qatar submitted to the Qatar Foundation Migrant Worker Welfare Initiative summarises the evils of the system of brokerage through which workers are brought into the country. And the quote is, the high costs that workers have to pay are far beyond the maximum allowable by their country of origin governments and are essentially a form of extortion by agents to secure the jobs in Qatar. To pay these costs, they commonly sell family assets, enter into debt with usurious interest rates, a practice that violates Islamic finance ethics. The money paid to recruitment agencies is a type of investment for the migrant worker, but more importantly, I've lost my place. But more importantly, if he has to borrow money to pay these fees, there are substantial pressure to follow through with whatever contractual arrangements are made in order to repay the debt. And so on. And goes on to describe exactly what I've just described before about being stuck in whatever circumstances they're being given. Now, full disclosure, I was the author of the report that they're referring to, so there's a kind of a personal element to all of this, I must confess. It's kind of a cathartic thing for me to be talking about this now. I was one of the outsiders that they were referring to. Now, it should be noted that this was written during the fully operating kafala system that's now been significantly modified in a series of legislative reforms in Qatar. employees could not leave their employer or change jobs without the employer's permission, and could not leave the country without the employer's permission. Now, if these researchers had been a little more open in their portrayal of this report to the Qatar Foundation, they would have pointed out that it was acknowledged that the recruitment agents themselves are forced to charge workers because the employers refuse to pay. And so if they have to pay, then the only source of that is the workers themselves. And all of my interviews with these agencies lamented the situation, but said in order to stay in business, we have to do this. I'll have to move fast. In addition, what's not acknowledged at all in their analysis is the power of the kickback payments to the employing company that is paid from the workers' charges. I can skip this. Thus, if we look at the system as a whole, the origin of what I consider to be the corrupt system begins with the employing agency at the country of destination, which wants to minimize its costs for the contracts they're fulfilling. But in reality, everybody is implicated in one form or another in the structure of this recruitment system. They go on to argue, in the Bangladeshi moral discourse, brokers carry the pejorative descriptor of Adam Bapari, or traders in the progeny of Adam, typifying the view which gives all the power to the broker and deprives the migrant of any agency or control over the process. Similar discourses which demonize recruiters and victimize migrants prevail in other countries. In Bangladesh, such discourses have led to attempts to eliminate or heavily regulate migrant brokers through state-controlled manpower export companies. And I might note that in 2021, this research organisation did in fact publish a paper calling for the regulation of these local sub-agents. Well, most of the outsiders, they argue, have focused on recruitment through interviews at destination, in the destination countries. That was not true for our report. In fact, I went to all of the 5 main labour origin countries, interviewing all sorts of people. So they argue, while the hardships encountered by migrants may lead outsiders to regard their migration as a failure, the migrants themselves describe the process in more ambivalent terms and appear to accept hardship as well as some cheating by the brokers as necessary costs for in their quest for a better future. The cheating is not explained, but I think it's what I've just described. Now, they use a couple of case studies of in-depth interviews with some returnee workers that have returned from Qatar into Dhaka. And they said Akkar, who was one of the case studies, was subjected to contract substitution and irregular pay. This would have been viewed by the human rights advocates as extreme exploitation that would limit his ability to break out of poverty or debt. While Akhtar did face hardship, he was able to overcome it through family support and by accumulating savings that would eventually put him on a stronger upward trajectory. I'm not sure what to conclude from this in relation to their arguments, because I think that this is an acceptance of exploitation and violations of rights for long-term gain. It's this kind of trade-off, and is that acceptable? And how do we make that judgment a very difficult position to take? If they don't pay, they don't get the job. It's as simple as that, whether they like it or whether they disagree with it or not. And this is the normative playing field of the migrant labour recruitment industry. And frankly, I'm not convinced that there is any dignity for migrant workers in the proposition of turning a blind eye to the corruption or cheating, as they put it. In their conclusion, they argue the research shows that migrants are aware of the risks of migration through informal brokers, but that they prefer to take them because they can draw on the moral contract and call in the support of their kinship network should anything go wrong. What also seems to be implicit in the Bangladesh critique is that international human rights law and the human rights advocates implies a charge of imperialism. Implicit in the cultural relativist critique is an interpretation of human rights advocacy as the claim of non-Western peoples should be governed by Western opinions rather than their own. And of course, the paradox is that many in Qatar, during the decade and all the debates about migrant workers for the World Cup, Qatar itself felt that human rights attacks on Qatar to be imperialistic, orientalist, racist. Okay, so question, what damage, for example, has been made by characterizing migrant workers as victims of trafficking, of forced labor or modern-day slavery or debt bondage? To grant migrant workers agency does not mean that they are no longer victims. To acknowledge the security role of local recruitment agents who act as responsible community members does not mean that the migrant worker cannot be caught up in the corrupt practices of job recruitment and placement, which they end up accepting. It's always been obvious that young men and women in countries from South Asia and increasingly from Africa find themselves desperate for work abroad and cater for their families and accept the conditions facing them. But does this place them outside of the discourse of him? If you can just give me 2 more minutes, I'd appreciate it. The reality is that workers in the circumstances are not even told precisely where the money that they pay goes. They are not given itemized an account or even a receipt for the money that they pay. So they can't be really complicit in how their money that they pay is distributed. For that is perhaps what is being implied by the cultural relativist position. Grant them a voice, grant them agency. However, if that is done, then you must grant them responsibility for the conditions and the corrupt practices that they find themselves in. Victimhood, it seems, has become, in cultural relativist terms, something to be abhorred and an unacceptable stigma. If a person is classified as a victim, it seems that they will lose their humanity without their social context being understood. On the other hand, victimhood allows for the invocation of human rights principles and a moral outrage to the violations of those victims and to seek legal remedies and justice for them or with them. So to sum up is in my abstract, but let me just give you a few quotes from Brian Turner's work on cultural relativism and human rights that I find useful for discussion. Firstly, he says, human rights legislation functions as a normative constraint on the actions of the state, but it also enters into the social action of individuals. This moral imperative has increasingly assumed a global context. While we recognize the force of the notion that cultures are relative, it does not follow automatically and necessarily that morality is relative. And finally, there's a broad range of human activity that is commonly held to be an offence against humanity. These common agreements are the stuff of modern human rights legislation, and the fact that states constantly in practice disregard such codes is irrelevant to the argument that there are agreements about how people should be decently treated. Thank you. I'm sorry I went over that.
Thank you very much, Dr. Ray. for this interesting presentation. And now the floor is open for questions and comments, if any. Yes, Dr. Jamal.
شكرا دكتور معتز، والحقيقة أشكر مركز دراسات التشريع الإسلامي والأخلاق على هذا الطرح المتميز والدقيق في ذات الوقت. الحقيقة أشكر أيضا الدكتور معتز الفجيري على طرحك المتميز والرشيق في ذات الوقت. الحقيقة أنا في حيرة في مسألة الدساتير. يعني حسب معلوماتي أنه أول دستور وضع في مصر عام 1879 وضعه محمد شريف باشا، وتقريبا الدساتير ما يقرب من 10 دساتير. الإشكالية في أنه النصوص أو الدساتير في غالبها بتحمل مضامين جيدة ومتميزة في الحقيقة، ولكن الواقع مختلف. وأنت يعني أشرت بشكل أو بآخر في كلماتك لدستور 2014 في باب الحريات تحديدا، وأيضا الكلام فيه متميز في باب الحريات، ولكن نجد الواقع سواء من هذا الدستور 2014 أو ما قبله هتجد أنه المسألة تختلف اختلاف جذري عن الواقع الممارس. لماذا؟ يعني هل لديك تحليل لهذا الأمر؟ الأمر أظنه فيه تفاصيل. دكتور راي، حضرتك مشكور، تحدثت عن قضية أيضا دقيقة وهي مسألة حقوق الإنسان.
فيك احكي إنجليزي عن المعروف؟
الدكتور معتز ربما ينوب عني في ذلك. أقول مرة أخرى أنه مسألة حقوق الإنسان هي أيضا مسألة مهمة، وتحدثت بدقة عن قضية العمالة في مونديال قطر، والغريب أنه أصبحت أيضا مسألة حقوق الإنسان بتستخدم من جانب للابتزاز بعض الدول، ومن جانب آخر للادعاء بأنهم يقفون مع الشعوب المقهورة إلى آخره، ولا يظهرون أنهم يكونون أصحاب مصالح من وراء ذلك. بعض الدول بطبيعة الحال، لا أقصد والإدارات في الدول ولا أقصد الأشخاص. ومن ثم أثير للضغط وابتزاز قطر بشكل أو بآخر في مسألة المونديال. قبل المونديال بطبيعة الحال أنه حقوق العمالة وغير ذلك. هل لديك أيضا تبرير من وجهة نظرك؟ ولا أريد أن أطيل في الأمر حتى لا أرهق الدكتور معتز يعني في الترجمة. وشكرا لكم على هذا المؤتمر المتميز.
شكرا دكتور نصار. After your permission, I will collect some questions and comments, and then I'll give you the floor to respond. Any other? Yeah, Dr. Mashur.
Now, thank you so much. For those two presentations. I think they are very, very useful. Mutaz, thank you. Your case study is really very good because looking at cases is very, very useful. You know what's going on the ground. My question to both speakers will be in relation to approaches, because I get these questions all the time. Your Makasidi perspective, which you looked at, you find out that sometimes, a lot of the time, the question is this approach actually, what you are just doing is subjecting Islamic law to international human rights law. You are just trying to subject it. You are bending Islamic law. It's similar to what Dr. Samer mentioned earlier when Marwa presented her paper that we need to, citing classical materials, we need to be cautious about it. It's both ways. If you are too much to classical sources, it is accused that, well, it may not meet our time now. If you use the Maqasidi, you are just bending Islamic law too. Now, how do you address this issue? Now, similar to what Dr. Ray mentioned, the cultural relativist approach is also, it's relevant, as the authors of the article indicated. But then, victimhood. My perspective is this. There's this concept of, for example, in human trafficking, the consent of the victim makes no difference. Now, if the victim says, well, I'm happy, this is okay, and things like that, well, he's consenting. But in relation to, when we talk about ethics, even though it's relative, but there are some inherent universal ethics in the mind of everyone that really this is not good, no matter how you want to look at it. So sometimes there's a need, even though we want to look at things from a relative point of view, at SOAS, we talk about, for example, globalization. That is globalizing things. Using the global concepts, localize them, bring them, and localize them in your own way so that it meets your cultural needs. Rather than, do you think perhaps maybe globalization can counter a strict cultural relativist approach that says that, well, you cannot call people victims and things like that? It's about approaches. Okay.
Any other question? You wanted to?
I just had a small question for Dr. Motaz. You spoke to this a little bit at the end of your presentation, but I was wondering if you could speak to the importance or relevance, if you think there is one, of who is sitting on the court. So I know you talked a little bit about that in the context of judicial independence, but maybe also you could speak to different types of, and you did also about the type of training that you think people should have. And I'm also wondering, you talked about the court, I think, as sort of from an institutional approach, and I'm wondering how much does it matter who was sitting on the court at the time? Have you seen change over time based on the makeup of the court as an individual change, or is that just something that's less important to your analysis, and instead you can think of it as kind of an institution and take the individuals out of it? So thank you to both for your wonderful presentations.
One last comment or question? Okay then. اوكي دكتور معتز.
أسئلة يعني هبدأ بالسؤال الأول فيما يتعلق بالدساتير. طبعا الورقة بتاعتي أو البحث أنا مقتصر فقط على العلاقة ما بين ارتكل 2 المادة 2 في الدستور المصري وبعض الحقوق المرأة، حرية الرأي والتعبير، حرية العقيدة. ما بتناولش وضع حقوق الإنسان في المجمل، لأنه بالتأكيد دستور 2014 نفسه فيه إشكالية شرعية أصلاً. يعني هو جاء في سياق صعب، في سياق يعني عنف، وفي سياق فيه إقصاء طبعاً في المجتمع المصري، لكن ده خارج عن إطار البحث. لكن من ناحية أخرى إنه أيضاً في الفقه في الأدبيات الخاصة بالقضاء والدساتير يمكن أن يكون في نظام سلطوي ويستخدم الدساتير والليتيجيشن من أجل توسيع مساحة الحريات. يعني ده كان موجود في مصر يعني في الثمانينات والتسعينات والألفينيات، كان نفس السياق سلطوي، لكن في حركة من الهيومن رايتس ليتيجيشن قوية، المجتمع المدني والمحامين، وبيحاولوا يستخدموا التراث الطويل للقضاء المصري في ان انت تحاول تحصل على بعض الحقوق. لكن لدينا بعد 2014، ولهذا السبب انا انتهيت في الكونكلوجن اتكلمت عن انه في اشكاليه تتعلق بمصداقيه القضاء، لان لدينا تسييس كبير لمؤسسه القضاء المصري. وواحد من اوجه هذا التسييس هو دور المحكمه الدستوريه العليا نفسها، وده يعني I will talk about it again مع دكتور كاترين، انه المحكمه الدستوريه اليوم يعني الجيش في جنرال دخل في تشكيل المحكمه الدستوريه. يعني طول الوقت المحكمه الدستوريه كانت بعيده عن تاثيرات السلطه بهذا الشكل. كان في تاثير طبعا، ولكن كان في برضه قدر من الاستقلاليه الموجوده. لكن اليوم احنا بنتكلم على اداء المحكمه طبعا بيبدا ينحرف، وده ممكن يبقى له تاثيرات كبيره على حتى الحقوق التي اتحدث عنها او على مدى مصداقيه المحكمه. لكن بشكل عام يعني اكيد الدساتير كنص مش بالضروره تكون مطابقه للواقع، خاصه في السياقات اكيد في السياقات السلطويه، لكن ده خارج عن اختصاص الموضوع اللي انا بتكلم عنه. Moving to دكتور بروفيسور مشهود on subjecting Sharia to international human rights law. No, I don't think it's like that. I think it's subjecting Sharia to the social reality. to the demand, societal demand. This is what we are seeing in the region. And I think looking at the judiciary performance is instructive because the court also respond to litigation, respond to societal demand. And I think throughout the history of Sharia, it evolved because of the societal demand. Even the idea of Maqasid Sharia itself was evolved in order to give dynamic spirit to Sharia. So I think it's normal. I mean, the society, for example, the question of oral divorce or unilateral divorce, there are segments in society who demanding that. And they are Muslim, and they have different idea about this. So it is society and the debate within society that could lead to the evolution of Sharia as well. And this is, I think, something legitimate because it is not, Sharia is not stagnant. It's evolving to the societal needs. For example, the Egyptian legislature in 2000 amended the law in order to consider khula'. Khula' is already in the Quran and already in the Sunnah. Why the legislator remember only khula' in 2000? Because the society also changing. This is very important. And I think this is what we are seeing in the Muslim societies and Arab societies following the Arab Spring. And we have to consider the changing context. And I am very careful about that when dealing with case studies, because debate in Tunisia is different, in Morocco is different, in Qatar and the Gulf is different. So one reform that you can think that you could see from a human rights perspective as very minor, it is not minor within the context. For example, in Saudi Arabia or Egypt, but the debate is entirely different in Tunisia. Right now in Tunisia, the report which I cited about, they are debating if ijtihad can happen within the text. Yeah, that the maslaha is above the text. This is the debate in Tunisia. We are not in this stage in Egypt because the society has not evolved to that degree. But this is the diversity that we have in the Muslim society. So I don't think it is subjecting Sharia to international human rights law. It is subjecting it to the reality on the ground. Dr. Catherine, it is very important. It is very relevant to in court as mediators when it comes to interpretation and mainly in Islamic constitutionalism. The composition, of course, is very important, and I dealt with that in my paper, but the general one on court as mediator in Islamic law and human rights, because I think the historical institutional history of the Supreme Constitutional Court in Egypt is very particular, and even the establishment of the court in late 1970s and how the authority wanted to establish this court in order to legitimize liberal market economy, so they have to give it more independence. So prestigious judge when he joins the court, so they also try to balance between political Islam and liberal and secular forces. And this theory responded to this balance. So some element of the theory respond to the conservative element of society, other element respond to the progressive element of society. The court maintained its composition throughout its history, but these things started to change in early 2000 because Mubarak was fed up from the court and wanted to curtail the independence of the court because it came with a price. So they started to manipulate the appointment. But right now, following the Arab Spring and following the military coup in Egypt, I am not that optimistic of this future of the court because we have seen some changes in the case law, but when it comes to other issues, when it comes to Sharia, it is still consistent. But when it comes to, for example, some political issues or some major economic issues, the court started to be very much supportive to the military and the government, and also the composition, because as I said, they appointed a military general among judges, and this is very unprecedented in the history of the Supreme Constitutional Court. Thank you.
Thank you very much. Dr. Jamal Nassar was talking about the politics of human rights, politicizing human rights by using human rights for political objectives or interests, either in political pressure on some countries to achieve some political objectives or interests, or to have some more claims. To pretend that they are for a good image and that they have a political moral claims.
Yeah. I think that's often true. as I suggested, that there was a perception that many of the critiques that were coming against Qatar after the World Cup was announced in 2010, that these were very much politically oriented and against the very idea of Qatar, against Qatar having any sense of achievement in getting the World Cup. And there were calls right until the very end to actually stop the World Cup from going ahead. And there is going to be an article, a paper is going to be published fairly soon, I hope, where one researcher has actually done a comprehensive analysis of the media reports going, throughout the whole period. In fact, having thousands of articles being analysed from the point of view of these kinds of issues. So I think that there have been disingenuous reporters and analysts and researchers who were not really, it was like the bandwagon, as we call it. Once the Qatar got the World Cup, it was fair game. It was an easy thing to do to criticize Qatar. And they made their careers on it over the last 10 years. Human rights organizations, new NGOs developed precisely through the critique of Qatar. So it's quite, but sometimes it's very, very difficult to know or to prove what I've just said. To prove that there are as a racist element or an Orientalist motivation for these critiques. It's very difficult to prove because they're very careful in the language that they use, language which is very often very manipulative. The Guardian newspaper was typically very manipulative of a whole range of issues that I took and many others took umbrage against. So I'm not sure if that answers your question, but thank you very much, Dr. Masood. The idea of globalization I'm quite familiar with. That's been around for some time. And the idea that, victims can in fact consent, but I think in law, you cannot legitimately consent to your own slavery, for example, right? It doesn't matter if you consent. And I think that what I didn't get to read out, because I was anxious about time, if I could read it, I think answers your question about how to get the two approaches. And I think what's basically required is that an allocation of issues which are local issues, which are typically local issues, that is culturally relativist issues. I'm sorry, I get very dry because I'm on this medication. Oh, thank you, it's okay. So seeing them as victims of fraud and corruption, of human rights violations, is more likely to prompt institutional action to stop and prevent further violations. It may be concluded that some issues, such as religion, dress, language, food, and other beliefs and traditions, etc., are quite variable, and cultures should have the freedom to practice them. However, practices such as slavery, sexism, corruption, bribery, human trafficking, and forced labour, amongst many other human rights violations, should be judged by universal standards. So I think that's the globalization process, is to say we can easily distinguish between what should be considered local and what should be considered under universal judgment. Thank you.
Thank you very much. Yes, please.
Assalamu alaikum. Thank you to both of the presenters for your papers. Dr. Ray, I wanted to ask you how, and I gathered, your position not only from what inspired you to do the research in the first place, what you found, the corruption speaks for itself, the kickbacks, and obviously the exploitation of the workers and their vulnerability once they're, in the host country. But how do you feel having gone through the response to the work that you and others did? I'm asking because I would have been of only one mind about this issue, but listening to what the anthropologists from Dhaka have shared, I wonder if it's a choice of the lesser of two evils for people who don't have another economic prospect. So I'm thinking about, liquid modernity and this idea that when conditions in one area are no longer favorable to a factory owner, they just shut it down and move it to another part of the world. And so even though working for pennies on the dollar is universally bad and very exploitative and everything that comes with it, for that to kind of leave as an option, I'm trying to wonder what it means to be someone who would prefer this type of a condition, and so what their alternative would be. And I'm wondering if the anxiety of losing the option, even though it's a terrible option. So I was just curious, because your work has been so intimately, you're so familiar and so embedded in this question and all the different actors through all of your interviews. Are you at all of two minds about kind of the relativist argument that's been presented from Bangladesh, or are you, because similar arguments have been made about nuclear family systems, like from India and the Asian values, and child labor, right? Similar arguments have been made by societies where child labor is an integral part of the economy, and people say, well, if you just take a universal standard against child labor, it's not, it might be harmful to our economy, educational progress notwithstanding for children. But there'd have to be something to replace, right? What would be, so I'm wondering, that was a very long-winded question, but maybe you can share just your feelings.
I'm happy to answer it. In fact, it's interesting you should use that example, because I actually had it in my paper. I skipped over the idea of like child labor is a very good example, where you have very clear, UN Convention on Protection of Children. But the reality is that there are many children who must work because they can get work and they support their families. Even unaccompanied minors crossing borders, particularly in Africa. I've seen a number of articles about that, and where it just has to be accepted that this is a fact of life in certain areas. And workers who come here, why do they keep coming? Which was the title of one author's analysis. Because they need to. I mean, the labour market is not a charity. It's not as if Qatar can say, we're helping these countries. Well, they are, but indirectly. And the fact is that workers who come here get far more than they would earn if they were back home, even if they could get a job back in their home countries. So they know what is actually beneficial for them, even if it's in the long term. My complaint is that it's the poorest workers who are paying this money, and all of that money places them in a tremendous position of vulnerability, but they have no option. We are, we've been for years advocating on this issue, and there have been international campaigns against this, but it hasn't worked. Why? Because, I mean, it's still ongoing. Maybe it's too early. These things take a long time to develop. But my argument is that the kickbacks that come from the workers' payments are what drives this system. It means that in Qatar, for example, there have been far more workers on construction sites than was actually necessary. Why? Because some human resource manager or facilities manager or procurement manager, some people are getting these kickback payments And the more workers they bring in, the more they get in their pockets. Right? Now, the strange thing about all of this, and I have been to many meetings around the world on these issues, is there are people who say, well, we know about this. Everybody knows about it. It's like an open secret. Everybody knows about this, but nobody will do anything about it. Why? Because it works. The what's called the level playing field that includes all of these this bribery and so on is how the system works. To begin to really change it will create a tremendous disruption and probably dangerous, you know. But to know that a human resource manager is getting $500,000 a year, and I'm only saying that because I actually have the evidence. But that evidence, which is apparently actionable, nobody wants to do anything about it. It's too much of a disruption to begin to do that. Corporations themselves, they say, you know, we can't operate ethically because it's costly. If we operate ethically, we won't be able to compete. And one of the major corporations that was here working on the World Cup, on the railways, called QDVC, which is a sub company of a very large multinational corporation based in France called Vinci, they introduced an ethical recruitment process. But after they did that, and their commitment to continue to do that, they stopped getting contracts. They're virtually doing nothing here now. They had I don't know how many thousands of workers. They had their own accommodation sites, which were brilliant, beautifully constructed. Now they don't have enough workers to maintain those sites because they're not getting contracts, because they have to act ethically, they have to recruit ethically, that is, not charge workers. And there's new schemes of reimbursing workers this money. The Supreme Committee for the World Cup introduced an excellent scheme and got the corporations contracted to the World Cup to give back the money that the workers paid. Right? But that's not the solution, in my view. But it is obviously helpful. I'm not sure if I've answered your question, but the thing is that, you know, it is a system. And we disagree and don't like some of the elements of that system. But, you know, people work, they support their families, they improve their circumstances back home, and all of that actually occurs. The countries of origin rely a great deal for their GDP on the remittances from their nationals working abroad, particularly countries like Bangladesh and Nepal.
Thank you. Dr. Samir?
Well, thank you very much for very interesting presentations. I have a couple of questions out of curiosity. What's the mechanism of raising issues to the SCC? I mean, is it done by lawyers, judges, state? So this is the first one. The second one, to which extent are the decisions of SCC is detailed in terms of their like ethical or legal reasoning of their decisions? I mean, do we have sources? Can we like analyze their, I don't know, sources to understand the foundation of their decisions? And even when they say that some issues are قطعي, universal, do we have like a detailed explanation of this opinion or this decision? Apart from these two questions, I have just kind of a comment, which is, it seems that beyond the theoretical debates about maqasid al-sharia and its applicability and how to apply it in many let's say, faculties of Sharia and institutions and stuff, it seems that in reality it's working. I mean, at least it's implemented in one way or another, which, I mean, from my understanding, well, it seems it's important, it's critical, and specialists need to maybe to invest more on developing this system of thinking, or if we want to, I mean, according to your analysis, it's kind of moral and ethical reasoning, right? Yeah, thank you.
One follow-up point here regarding Maqasid Sharia. I think to what extent that do you think using Maqasid here in the post revolution, let's say, is a kind of a political action? Because we know that Maqasid Sharia is one of the key tools that was used by the political Islam to build their comprehensive system, the key claim that they used to say, and to adopt, and recall some selectively the Islamic jurisprudence in their political project. So to which extent that you think the regime, the new regime in Egypt was trying to take this tool from the Islamic political Islam and to justify its position? So my opinion that it's not a societal demand; it's almost political action. So to just disregard or to put this tool in action just to prevent our enemies to use it.
So first point regarding the power of constitutional review. This is one of the issues that I think need to be reformed in Egypt, because it limits the scope of constitutional review in Egypt, because only lower court, judge in lower court, if they are convinced that there is genuine constitutional claim, they can refer the case to the Supreme Constitutional Court. So individual cannot directly go to the court like South Africa. I think the court in South Africa has very strong constitutional review powers. But in Egypt, because it's double-edged, authorities establish constitutional court, but they are worried about the constitutional court. They want to limit the accessibility to the court. But lower judge also use this, we can say like there is judicial politics also, because conservative judge will usually refer cases if they are not happy with the legal reform. And it happened in some, one of the cases, for example, in the law on religious freedom, it was developed by the court in the administrative, the Supreme Administrative Court, developed the law on religious freedom. But their colleagues in lower court, in the state council, they were not happy of this development, so they suspended the whole matter and referred it to the Supreme Constitutional Court. Since 2008 and until now, there is no decision. But they managed at least to curtail the new precedent developed by the Supreme Administrative Court. There is much judicial politics here, because there is tension within the judicial system also. There are judges have different views, have different perspective on how Islamic law can be applied and what is the space of ijtihad that can be allowed. So this is my first point. Second point, in terms of the details of the cases, yes, it is not that detailed. Sometimes it is detailed. It's not consistent. Sometimes it is detailed. Sometimes it is not. So yes, it is not like the Federal Sharia Court in Pakistan, for example. Or Supreme Court in Pakistan. When I compare, it is different. Supreme Court, they discuss the matter. In Egypt, yes, the case could be like 8-9 pages or 7 pages, but when it comes to big conclusion, like for example saying that this ruling is universal, you have to convince me why it is like that. No, there is no discussion, not detailed discussion, and this is area that need to be developed, I think. And that's why when I concluded my speech, I said maybe it's important in the future to find a way to appoint some few members of the court coming from Islamic background. I think it's very important, Islamic law background. It is very important because judges, they just received civil education in the faculty of law. They are not that trained in Islamic law. So you can find copy and paste between judge. It's very notable in Egypt. Copy and paste, like the same. For example, one of the precedents developed by the Supreme Court in 1975 on religious freedom, it is copy and paste until now, the same paragraph. So judges sometimes they are, and there is research actually made on family court in Egypt, and the researcher observed it's the same, that usually judge, they just copy and paste the precedent, you want to say? Huh?
Okay, yeah. When it goes to the Supreme Court, within the Supreme Court, there is a Shariat appellate bench, and it goes there, and the judgments are even more detailed there. And interestingly, they are all available in English and in the Federal Shariat Court website and the Supreme Court website. So those who want to access it, they can do that. Just for information. Thank you.
This is not the practice. You want me to conclude, or this is not the practice in Egypt. It is very brief judgment. I noticed one judgment made by a lower court, and it's very exceptional on blasphemy. And the judge, he's young judge. The judge actually made a judgment of 48 pages, and he was struggling to present a new interpretation of the blasphemy law in Egypt, and coming closer to the jurisprudence of the Human Rights Committee, arguing that blasphemy should incite to discrimination or violence. It is not just about criticizing religious doctrine. And it is very like one case, one exceptional case, but it tells us something about the new generation, especially those young judges who perhaps studied, European court, comparative law, foreign jurisprudence, so they want also to prove themselves in their judgment. But in most of the cases, it is very brief. The final question, Dr. Mu'taz, yes, the establishment of the Supreme Constitutional Court, yes, it was a political action. It was a legitimation by the authority. But once the institution is established and it is there, it could be used by all actors. So litigation in Egypt is very important. If anyone is familiar with the legal dynamics in Egypt, everything is, litigation before all court. We have, every day there are development in Egyptian courts. So usually lawyers, human rights defenders, they bring cases to court. People who wanted to challenge family court, in all trend, conservative, liberal, they go to court. So that's why there is case law, because you don't know the case law if there are no litigant. And this is the difference. For example, in Jordan, there is constitutional court, but there is no litigation. And Sharia court in Jordan are not monitored by the constitutional court because they have parallel judicial system. But in Egypt, you have unified judicial system, and litigation is a tradition since long time. People usually go to court, lawyer challenge court. But yes, the establishment of the court and the theory of the court, I think, yes, it was about competition with political Islam, and it was about containing political Islam, and perhaps also getting closer to Al-Azhar and trying to satisfy political trend in Islamist political trend in Egypt. But yes, the idea of maqasid was very important in the literature of Islamists, and challenging authoritarianism and challenging repression. This is another dimension of the debate I have not talked about, but yes, in terms of social movement and opposition. And it's clear in Tunisia, for example, the work of Rashid al-Ghannouchi on democracy and struggling against repression. This idea is present in their intellectual work, but we didn't have the chance to see Islamists in power in Egypt. It's only 2 years. If they are in power for some time, we will see how they will, if they started to be in the constitutional court, how they will develop their idea in practice. We did the whole model was curtailed. We don't know what will happen. We judge them from their writing, but we haven't seen them in power in a proper period of time to see, for example, the Muslim Brotherhood in power, how they will deal with these issues. Are they going to challenge the case law of the Supreme Constitutional Court, or they will extend, or they will maybe surprise us and develop liberal positions? We don't know.
Thank you very much, Dr. Mu'taz. At the end, I should thank Dr. Ray Jouradini and Dr. Mu'taz Fujeri for their presentations. And this is the conclusion of the fifth session. I should give the floor to my colleagues. Dr.
Thank you so much, Dr.
Sada.
Mu'taz.
Yeah.
We'll have a short break, 5 minutes. We have coffee and refreshments. You are welcome. Yes, before the concluding remarks. Okay. Thank you so much.
And we discussed different topics like public morality, universality, issues related to self-determination, the interplay between legal and ethical considerations when related to the idea of rights in Islamic tradition, bioethical cases, and some cases related like that has to do with constitutional institutions in Egypt, or the situation of labor in Gulf region, etc. As I said in my opening remarks, there's no way to cover all issues related to human rights and Islamic ethics, and apparently, as I mean, some of you has mentioned this during our discussions. For some of us, especially lawyers, they don't have like clear idea about what is actually Islamic ethics and how to deal with it, and also from the other side, like those like experts in Islamic law or theologies, they don't have like the whole picture of how human rights, I mean, the history and the discussions and the development of human rights discourse and laws is taking place. So I mean, in our preparation for the prospective publication, which is the main aim of this, is, as I said in the beginning, that to incite the thinking on these issues, and maybe to paving the way of how can we rethink, rewrite the discussions about human rights from more like ethical and moral perspective. So the intention is to produce a thematic issue in the Journal of Islamic Ethics, and my main remark here is we don't want to push those who are not, let's say, experts in human rights to write a substantial arguments in human rights. In the same way, we don't want to push like those experts in law to go deeply into Islamic tradition, and because they, I mean, I suppose it's not easy to offer a deep how to say analysis of these issues, but to look at the issues of human rights from the ethics perspective, from the ethical perspective. This is the main intent of this event. So hopefully the ethical and the moral aspect or element in the discussions of human rights, this is the main issue that should be highlighted in hopefully in all the contributions. As I've mentioned in my first communication with you, you have until the end of the year, I think it was 15th of December, to send the final, not the final, but the draft that we will send to the reviewers to review and to get it back to you. Hopefully, like let's say in mid of 2024, we would be like ready to I mean, we should publish the thematic issue, inshallah. So this is from my part. If you have any questions related to publication, to, I mean, any issue to the process.
You just explained the
Yeah.
process a little bit.
Okay, so.
Assalamu alaikum. Good afternoon, everybody. For those who were not there when I presented myself in the beginning of the conference, I am Muhammad Ghali, the acting director of CILE, the Research Center for Islamic Legislation and Ethics, and I'm also the editor-in-chief of the Journal of Islamic Ethics. As Dr. Samer mentioned, the proceedings of our activities, including the international conference, usually go to publication either in the Journal of Islamic Ethics or as an edited volume in the book series Studies in Islamic Ethics. Dr. Mu'taz is responsible for the series. I am responsible for the journal. And we are in the editorial boards with other international colleagues also. So usually what happens once we have the proceedings of an event, first of all, you will have a discussion with Dr. Samer to tell you streamlining your work, etc. In the coming period, we will send an email with the details. And then the papers that we will receive from him will be a point of discussion within the editorial boards. And at the editorial board, we only check the scope. Do they fall within the scope of the journal or the book series? First of all, we decide the journal or the book series depending on the number of the volume. So usually up to 8-9 papers maximum, it goes to the journal. Beyond this, we cannot have in the journal, it will be just too much. So it will be published as an edited volume in the book series, depending on the size. And then within the editorial board of either the journal or the book series, we discuss the submission as a submission, and we see the scope. Both in the journal and the book series, people who check our work, they check it because they want to know about the Islamic ethical perspectives. This is our brand. So we are not specialists in human rights or in bioethics in general or psychology in general, but how these fields interact with the Islamic ethics. As usually specialists speak about their own specialization, it's quite easy. It looks very difficult at the surface, but when you dig into it's not that difficult. So if you want to get a bit aware of the discussions in Islamic ethics, I would strongly recommend having a look at the journal and the book series. So we have now, I think, 6 volumes, 12 issues in the journal, and we have 5 or 6 books published in the book series. They are all available via open access. So if you just Google Journal of Islamic Ethics or Studies in Islamic Ethics, you will find them. You can download them, have a look, and see what kind of discussions, what we mean by Islamic ethics, and etc. It can be very helpful. I will not give suggestions about human rights. This is your own field, so you know where to go. So once we say that the papers fall within the scope, and I here second and support what Samer was mentioning, we judge let's say the thematic issue or the volume that it falls within the scope, not necessarily every single paper. So we find that the papers as a collection, they engage with the different fields, human rights in our case, applied fields, and the Islamic ethics as a collection in itself. And how to do that, this is a discussion between you and Dr. Samer during the coming period. Once it is done, we send them to the review process. We adopt the so-called double-blind review process, so the reviewers do not know you, you do not know the reviewers. You get the review reports shared with you with the recommendation, minor changes, moderate, major changes, etc. And then you work on them. Only in the case of major changes or major revisions, the revised version with your comments on the review reports go to the reviewers again to check that the revised version is okay and so on. So the very normal process, review process that happens all the time. In the case of the journal, once your paper is accepted for publication, it goes directly to the publication. So we don't have to wait for the issue because some people may be late, etc. We have this early or advanced articles. We have a section. So your article gets published, gets a DOI number, so people can cite it, no problem. And once we have the print issue, then it will be included in the prospective thematic issue. So no worries, if you do it earlier than your colleagues, you will not be punished by the colleagues who are late. So you'll get access. And all our publications are open access, and we do not ask money from the authors, so it's all covered by the CILE, by the research center. So this is usually how things work. If I may have some suggestions about the papers we have listened to and the discussions, I would say, for instance, the stress on the applied fields. Maybe if you have any suggestions of colleagues who can contribute to the prospective publications from, for instance, fields of environmental ethics, because this will bring some fresh insights about human rights, because here we will include the non-human beings and how far the rights of the humans versus non-humans should be balanced. So if you know any colleagues will write about this from a human rights perspective. So it's not environmental ethics, but environmental ethics and its engagement with the human rights discourse. This will be good. Artificial intelligence and robots' rights and all this stuff we have now, this discourse, it's emerging and coming, so it can be one of the applied fields. Can we consider robots as humans, non-humans, their rights? We have a big discussion now in the AI. Should robots be considered as humans, as slaves, as tools, machines? Should they be entitled rights, assigned rights? Or is it only obligations from at the side of the humans towards these robots, but they themselves have no rights? A whole discussion about this. Psychology also, we didn't have things coming from psychology. Any applied fields in general, if you have any suggestions, please feel free to communicate these suggestions with Dr. Samer. This is what I have from my side. Whatever deadlines you will agree with, we will accept. So we will not interfere into this. It's only our technical work as editorial board, either in the journal or in the book series. And I wish you a very successful post-conference work on your papers, an inspiring phase, and that you can come up with your papers as soon as possible. And I'll be happy to, and Dr. Simon, to receive any questions. Yes, Dr. Yes.
Did you say the people who give the paper first, and if they're accepted, they will be published online first? Okay, that's perfect. And a hard copy or a collection will come at some
This will come, yes. We have the system. Once any paper is accepted, so the review process is done, it will be published directly. With DOI number.
That's fine.
And then once we have the thematic issue or the issue that will be included in and will be published in print, this happens later, and then we do not have the problems of this gap, because you know, if you wait for everybody, some people will be punished,
so
and the others will get angry.
Give the paper for 6 months, mine can be published tomorrow, he can come out.
Okay, that's fine, that's fine. No, so the earlier the better, we say, and you get the reward, so it gets published. Yes. Yes, we know this. This was the agreement with the publisher Brill when we had it, that we have a mechanism that people who submit early, that they can get their work published directly.
Doing it with several other journalists, like International Human Rights Law Review.
Okay.
My article is online, but that's a hard copy will come and they will just do that for for later. How old is this journal? How many issues have you published before?
We have now 12 issues. Yeah, it's a Scopus Index journal, and we are Q1. So in our field. So it's to the best of my knowledge, the only journal on Islamic ethics worldwide.
Yeah, that's
we do not have,
specialized.
and it is Scopus indexed. It is Q1. So if you care about these technicalities, we are at the top in this regard. So no worries at all. And we publish in both English and Arabic. But we publish with abstracts in both English and Arabic and keywords, etc. Those who can write their abstracts in both English and Arabic will be perfect. If not, we take care of this.
Yeah.
Of the Arabic abstract and keywords, we do it, no problem. But if you prefer to have your own, to make sure that this is the language that I would like to have, and it should be like this, it's also your decision. Any other questions? Dr. Mashoud? Yes, they are. They are, yes. But
Yes.
maybe
I will send you
there is
the
a
guideline.
PDF on the website, but maybe
Yes.
Dr. Samer can send it to you.
Yes, I will send you the style and yes, exactly, the
Yes.
style of writing.
And
stuff.
you have enough samples on the website that you can see the articles that have
Yeah.
already been published, so you see it. And we follow one style, both for the book series and the journal, the same.
Yeah. Please.
Okay? Ah,
Please.
yes. Please, Paul.
Just to make sure, in principle, is it all right to invite co-authors who have no idea that this is happening?
As I said,
I thought of a colleague who would be able to maybe invite support internationally.
I think it will be perfect.
Yes,
Always
I
invite
think-
them. I would say they can write an abstract first before writing.
Co-author.
Co-author, yeah, of course. This is your
That's
decision.
great. I
No,
mean,
I
yeah,
thought
it's-
you would like
it's-
to
it's
invite
your
them to
decision.
participate in the issue.
That's also possible.
That's also fine, but then it's better that they send an abstract to Samer.
I need help on my article.
Okay, no, that's fine. That's fine. No.
That's fine.
No, it can happen that you have colleagues in your institution who may contribute to this and you would like to suggest this to them. Please do that. But then Samer will need first to see at least the abstract so that you will not write a full paper and at the end it's declined and would say falls outside the scope, which is not good news for any author. So it would be better, especially the fields that I mentioned, the applied fields, human rights.
For your time, for your efforts, and wish you a pleasant stay here for the coming hours. I don't know. Some of you will stay until tomorrow, I suppose. Also, I want to thank our research assistant, Sarah, and all the our admin team who helped to make this possible.
Yes.
Wassalamu alaikum wa rahmatullah.
Thank you so much. Thank you.